12-3.
12.
Much obliged. Grateful.
Seal number 5. Keeping Muttana.
Wasn't may not be necessary because one minute I have appeared.
May I make one submission in the
Appear for the
previous matter?
Apparent, my lord.
With
You
apologies,
appear for.
in the previous matter, my lord, the noting of office objection may be removed, my lord.
What is the office objection?
That's, I have not furnished second set of the IA and the objections, my lord, which is furnished with a memo of compliance on
When?
August, 13th August 2023, ma'am.
Is it there, ma'am?
Yes, sir.
I have filed both of them.
Just say that insofar as the office objection is concerned and a counsel for the appellant says that he has filed the second
Respondent,
set of the application.
respondent,
The respondent counsel says the second set of the application has been filed through a memo on
13/8/2024.
13/8/2024.
I have filed, my lord, two things, my lord. IA 1 second set and objections of commercial appeal second set. Both second sets are filed on the same day. Both are the objections.
Full stop. He has also filed the objections to the objections to the appeal. Full stop. The same be filed through e-filing also,
Please, ma'am,
within 1 week.
please.
Okay. That's it.
Seal number 5.
I appear for the apparent, my lord. This is a matter relating to forfeiture of gratuity, my lord. And there is a delay of 60 days in filing this.
Lord, there is some office note regarding process. Lord, that is not required because I have
Not
already
required,
appeared.
Now, what is your case?
My case is, my lord, that petitioner has caused loss to the tune of rupees 29.8.
You're right, but what is the prayer made by him? What is he seeking? Gratuity?
Gratuity. He is seeking gratuity, my lord.
Under which act? Payment
Under
of
payment of gratuity act, under 4(6), my lord.
See the provision. What does the provision say?
Provision section, I have mentioned, reproduced in page number 10, my lord.
Just read that.
I'll read that, my lord. It is submitted that the appellant bank forfeited the gratuity to the rest of the respondent for causing financial loss to the tune of 9.22 crores.
Just the payment of gratuity.
Page number 10, my lord.
Yes, yes.
22 crores in terms of section 4(6) of payment of gratuity act 1972, which reads as under 4(6). Notwithstanding anything contained in subsection 1, the gratuity of an employee whose services have been terminated for in any act, willful omission or negligence causing any damage or loss to or destruction of the property belong to the employer shall be forfeited to the extent of damage or loss caused. B, the gratuity payable to the employee may be forfeited if the service of the employee have been terminated for his riotous or disorderly conduct or any other act of violation on his part. If the service of such employee have been terminated for any act which constitute an offence involving moral turpitude, provided that such offence is committed by him in the course of the employment. Here what happened, my lord? The learned single judge, basing on 4(6)(b), says that because the bank is not in order in forfeiting the gratuity, because there is a moral turpitude, it has not been convicted as per Ajay Babu's case of Apex Court.
Lord, it is not quantified. Lord, kindly have a look at page 55.
No, it not been quantified, but the charge is also for causing loss.
Yes, my lord.
So that will be gone into and then decided.
Lord, no, kindly have a look at the page number 55, the order of punishment. Lord, it is not automatic. They will have to quantify the loss, and to the extent of loss cause they can recover. There is no dispute about it.
Now, what are the charges which were framed?
Lord, he has granted several housing loans. Some of them were not recovered. Now, my lord, it is not quantified in the order of the punishment.
Understanding.
Yes, ma'am.
If the charges are that because of your omissions and commission loss has been caused.
Yes.
And it appears loss has been caused. Loans granted could not be recovered, that's a loss. If those charges have been proved, what else need to be proved? Quantification is irrelevant.
My lord, it is relevant because
How?
my lord, it may be posted for admission. I'll get the judgments. My lord,
And mind it, we don't mind. The finding of the learned single judge is, it's only moral turpitude.
Moral
that
turpitude
must
is
be
not
done.
there at all.
That is not, is
Yes,
not.
my
it
That
is
is
not,
exactly.
it is not just moral. I will submit, my lord, because if when it is moral turpitude issue is there, my lord, conviction is required.
It is not there.
That he is right, but that's
Yes.
not the case here.
It is not a case of conviction.
It's a case of loss.
Then, my lord, that has to be a quantification. I will refer to the judgment and I will argue the matter.
My lord, in this case, he was.
Delay may be condoned. It may be posted for admission, my lord. I will get the judgment.
And where is the finding of the inquiry officer?
Inquiry officer is produced, man.
To us. And how much is the gratuity payable? How much amount?
6,80,000.
Tax 80,000.
Is it your case? It is the loss is less than 6 lakhs?
No, it is not my case. My case is, it is not quantified.
That's right. That's the only case. It is much beyond 6 lakhs. Now, where is the finding of the inquiry officer?
Inquiry officer finding they have not produced. They have produced only order of compulsory return.
Findings of the inquiry officer.
Just say this, you appear for the respondent, no?
I am appearing for the rest.
So-and-so is appearing for the respondent. And as such, notice to respondent. Sole respondent is dispensed with. Full stop. At the request of counsel for the respondent, re-notify. You get the inquiry officer
Yes, my
report
lord. I'll
also.
file the memo, my lord, along with the
That's
inquiry
the,
officer's
that's
report.
the charge according to you.
Charge, that is the charge is page number 10, my lord. Page number 10. Page number 8. Sanctioned many loans without verifying the antecedents of the borrowers and on the basis of the fake fabricated salary certificates. Purchased several high-value checks exceeding his discretion power, despite instruction from the controllers not to purchase for several persons.
See, we want to see the charge sheet and imputation also.
Yes, my lord, it is there.
And where is the imputation to say that loss has been caused? Where is the
I'll
imputation?
produce, my lord. Along with the inquiry officer's report, I'll produce.
Okay, just give it in second week of February.
Yes.
17-2.
Much.
Case number 6, Srikanth. Hearing to the state, my lord.
Services.
My lord, in this appeal, they have suffered 4 orders. And there seems to be no infirmity in the learned single judge's order.
Await service is there, this is respondent number 7 and 8 lots.
How are they relevant? Those respondents, they are not relevant. But what do you say on this?
Kindly,
And this post is for Kannada teacher.
Kannada teacher, and he doesn't have the prerequisite qualification.
What otherwise was the requirement
My
under
lord,
the rules?
the CSR rules say that a Kannada teacher has to have should have studied in Kannada or should have passed an equivalent of 4 years Pandit exams. Now, all along, right from 2005, my lord, when this, the clarification was challenged, that is at annexure U, wherein annexure U, my lord, the English translated version is at 99, wherein it states that the appellant herein has not got the equivalent exam of 4 years in Kannada language course.
Now, what are his qualifications?
He has done B.Ed in economics and everything else but Kannada. And he has got one qualification. He has studied something in Kannada, but it does not meet the prerequisite as prescribed. And therefore, he has suffered 4 orders, my lord. He has exhausted all his remedies
In Kannada.
before the appellate authorities and also has filed a revision and review.
Where is this recruitment rule of 24/6/23?
24/6/23, my lord.
He did not have Kannada as an optional subject. See paragraph 3 of the impugned order.
Please. (24/6/23), my lord, that's not forthcoming from the papers furnished.
See, if you see the advertisement at page 81. Simple advertisement, see the
Yes.
requirement. BA, B.Ed, Kannada as major
Yes,
or Kannada Pandit.
please. He has not, this Kannada Pandit is for 4 years, my lord, the examination. He hasn't qualified where this is concerned. And he wants to be a Kannada teacher.
Yes,
Lordship, kindly have it in day after tomorrow, Lordship, some person.
just say at the request of counsel for the appellant, we notify day after tomorrow.
Much obliged.
Just get that CSR rules.
Yes, I will.
24-1. Seal number 7.
Hearing for the government, my lord.
7.1.
Who has to be served?
My lord,
R6.
the appellants in the 7.1 are to be served now in 7. We had,
We will accept notice.
yes, my lord, the council, a new council has come now. We have served it on the previous council, my lord. We'll serve it once again. If,
You will accept notice, just show us the file. You are R6 in 7.1 or you are the appellant?
I am the appellant in 7.1.
And what is your status in the 7?
7, my lord, I have to see the upstairs.
Response
Yes,
for 5 and 6.
5 and 6?
Yes, 5 is dead, so 5, LRs of 5 are there. They are there in the.
So you appear for
12.1
LR of
Yes,
5 and 6 are being represented.
5 is Hanumantappa. You appear for them?
I'm not accepting, my lord. He is my,
Just show him the memo, please. Is it Hanumantappa or, yeah, Hanumantappa?
my lord, 6.5.
You would be appearing for Chinna Muniappa.
My lord, I am appearing for Lakshmi Narasimhaya, my lord. The LRs of Lakshmi Narasimhaya.
Lakshmi Narasimhaya, 5.
LRs of Lakshmi Narasimhaya.
Okay.
There are
Now,
two.
where is Lakshmi Narasimhaya in the other one?
The 5 A to C are the LRs of Lakshmi Narasimha. Correct. And 6.
And what is the very 7.1?
My
The
lord,
very
in
same order
7.1, my
was
lord,
being challenged.
I am the Archaka of the temple. It is a Inam Abolition Act, my lord. I am Archaka of the temple. My lord, therefore, I made an application before the Special Deputy Commissioner to grant of occupants' rights of the endowed land in favor of the temple.
Just
Well,
say this. Respondent number 6 in writ appeal number 219 of 2024 is still unserved. We find that the respondent number 6 in the said appeal is the appellant in writ appeal number 635 of 2020. The Lana Council for the, let's be clear. No, respondent number 5, don't say. Now you see the memo of parties in item 7. Item 7, just see the memo of parties.
5 and 6.
Let him have a look, let him have a look. He appears for Lakshmi Narasimhaya. He appears for Lakshmi Narasimhaya, LRs of LRs
Narasimhaya and
And Krishnamurti, both.
and Krishnamurti.
He's 6.
Krishnamurti.
Krishnamurti.
He is the third appellant in the 635.
The 6th respondent.
Fourth respondent.
She is the V. Krishnamurti, the GP holder of 123, my lord, in 635.
Then he is not the appellant in 7.1.
7.1, Lordship, may kindly see the
7
fourth appellant is Krishnamurti. Correct. The overleaf, Lordship, correct. See the next page. 7.1, the fourth appellant is Krishnamurti, who
Well,
is the
Oh,
6th
he is the
respondent.
appellant? How is the appellant? We don't understand.
My lord,
He is not the appellant. He is
he-
respondent number 4.
No, may I submit this? Lords, in
Oh.
635 is an appeal.
Okay, okay. There are cross objections also.
Yes. Lord, learned single judge Lords has allowed our writ petition in
Yes,
part.
ma'am. You are appellant in 7.1.
Yes,
What about 4, respondent 4?
respondent for the Anjaneya Swami temple. In 635. 635. In 635.
The appellant in 6.635
Yes, my lord.
is L. Girija,
L. Girija, Annapurna, and Vasanta Kumar.
and they are the legal heirs of Lakshmi Narasimha.
Lakshmi Narasimhaya.
But one of the appellant, one of the parties for whom you are appearing is also Mr. V. Krishnamurthy. He
V.
is also appellant.
Krishnamurthy is the GPA holder of all the three men.
He is also an appellant.
He is also, okay. Just cut that, ma'am. The respondent number 6 in writ appeal numbers 219 of 2024 is still unserved. The respondent number 6 in writ appeal number 219 of 2020 is V. Krishnamurthy. Stop. We note that the respondent number, the LRs of the respondent number 5/LRs and also respondent number 6 in writ appeal number 219 of 2024 are the appellants in writ appeal number 635 of 2020. Hence, the learned counsel who appears for the appellants, namely the LRs of Lakshmi Narasimhaya and V. Krishnamurthy, accept notice for respondent number, LRs of respondent number 5 and respondent number 6 in writ appeal number 219 of 24. Now, what has to be done?
My lord, I have to bring the LRs of the 5th A respondent, my lord. 5th A is dead now.
Oh,
Therefore, my lord, I have to bring the
Girija.
LRs of the respondent number 5A.
In 219, appellant, one of the appellant has died. Who is respondent in 635? We have filed application.
Muniappa.
Muniappa died. Muniappa is the appellant in 219 and one of the respondent in respondent number 5 LR in.
Now, who appears for the appellants in 219?
I appear.
You appear.
I-
So you file an application.
I have filed an application already. They have to file it in 630.
As we have been informed that 1A in writ appeal number 219 of 2024 has also expired, and an application thereof has been filed by the council for the appellants in the writ appeal 219/2024. The learned counsel for the appellants in 635/2020, wherein 1A Muniappa is also a respondent.
5A, my lord.
5 AM.
He is also a respondent, H. Muniappa, they say H. Muniappa. That is respondent number 5A. He also intends to move an application seeking the LRs on record, bringing the LRs on record. Just give the details into.
Yes, that's
My lord, the LR application is given, my lord, I will find it.
We can allow it. You have any issue? Why do you file an application? We will allow it.
Yes.
Say, where is your application?
Lord, sir, filed that application, Lord, the IA number 1 of 24. It's filed on 27 July
Just
2024.
cut that and just say that the H. Muniappa,
Delay, sir.
the appellant number 1A,
2 of
219 of 24,
2.
who is also respondent number
5A.
51A,
5A. 5A.
5A in 635 of 2020. Comment on an oral request made by the, you just say that the application having been pressed by the council for the appellant in 219 of 24, and also on an oral request made by the council appearing for the appellants in 635 of 2020. You have the LRs details?
Yes.
Show us the LRs whose names have been shown in the application being one of 2020, being one of 2024 in writ appeal number 219 of 2024, namely Jaraganahalli. What is that? No.
Village, my lord, that Jaraganalli.
Where are the names?
names.
Jaraganahalli.
Where are the names? But does your application show the names?
Yes, in the first.
Show us.
one ನಿಮಿಷ.
What is that application? Man?
No, they are not filed. Yes.
Lord, sir. One Srimati Rajeshwari.
Where are the names?
Manjunath. See the application.
Where are the names?
Where is that application?
Your application doesn't reflect the names.
It does. Application number.
Where is our application here?
ನಿಮಿಷ ಕೊಡಿ ಮೇಡಮ್ ಕೊಡ್ತೀನಿ ಮೇಡಮ್
Namely, Srimati Rajeshwari M.
next week next application
1A and Shri Manjunath. Are brought on record. I filed it.
That's what.
Just cut it, man.
That is a 2 of 20.
Just cut it. We have said, na, the earlier order. You have also not filed.
Filed lots, but I think there is basic.
But where is the filing details stamp here on this application?
My apologies. Kindly pass it on.
No, we will file it.
Yes.
Where we have said, no? He also wants to file earlier. Just say that. The learner counsel for the appellants in both the appeals states that they shall file application bringing the LRs of H. Muniappa on record. That they request re-notify. Just give a date. Well, one submission, Malik. I'm the 7th respondent in the writ appeal 635 of 2020. There's some urgency. What is that? My lord, the urgency is, my lord, there's this
two plots of land, my lord. We are concerned with land in survey
You
number.
are not the appellant.
My lord, we have come on record and got ourselves implemented.
Let them come.
No, my lord, one submission. We were not a party before the learned single judge. Even though the land was purchased by us, we had developed it by putting up an apartment building. And nobody brought it to the notice of the learned single judge that we were the persons in possession and development of the property. The learned single judge passed an order directing the state to take back that land in survey number 39. Thereafter, writ appeal 635 was filed before my lord. When we came to know of it, we came on record and by filing an application which was allowed. And on 20th December 23, this Honorable Court was pleased to pass certain orders to protect the possession of the property, 20th December. Now, my lord, because we have put up an apartment building and we have put up, there are more than 400 plus apartment owners in the project. This entire case, my lord, creates certain amount of uncertainty amongst the buyers who are there. Therefore, my lord, there's some urgency.
My lord, this court, my lord, by order date 20th of
They give a
December.
date, ma'am. March.
18-3. Eight. Serial number 8.
I am for the appellant, my lord. This is submission with regard to the R4 and R5 in the writ appeal, my lord. They are not party to the proceeding in party to the in the writ petition, and the husband and father of the appellant, respond number 4 and 5 are parties to the proceedings, my lord. Now we have filed IA for bringing LRs, and during the pendency of the writ petition, my lord, the R4 and R5 husband and father was died. IA was pending, that was not considered, and the matter was disposed of on merit. So I filed IA for permission as well as the IA for bringing LRs and abatement, my lord. And we do not know about the death, the date of death and year, my lord, because in that IA also not mentioned.
Shows that file, ma'am. Now, who have died?
R4 died.
What is
R4
the name?
in the WP, writ petition, my lord.
Huh.
Srinivasa Murthy. And died, and during the pendency of the writ petition, he was died. And
What is the name?
Srinivasa Murthy.
R4, okay.
During
So
the
you have brought the LRs.
Please, my lord, in the writ appeal. What office has raised objection, date and year of the date, month and year of the this one, and you are not produced the death certificate of the R4, my lord.
How do you know he has expired?
No, after this one, during the pendency, we after this one, service of notice to the respondent 4, my lord.
Yes.
We got knowledge that he was died. That time we have filed application.
Where is the application now?
In the writ petition, it was there.
Writ petition.
In writ petition, application is there.
So
But
what about this appeal?
this appeal, we have filed IA for bringing LRs.
Which is the number?
IA 1, 2, and 3, bringing setting aside abatement and delay in filing application.
IA number?
IA number 1 of 23, my lord. Sorry. Order 22, Rule 4, on 2nd February 2023, we have filed.
What is the number?
IA 3/24, my lord. 3 bar IA 1/24 delay in filing application, 3/24 for bringing LRs, my lord.
How many applications are there?
Three. We have not filed yet. Three is not there.
Just say that there is another application. What is 2 of 24?
Who is bringing the permission to prosecute against the permit the appellants to prosecute appeal against legal aids of responding to court. That is IA2. Not pressed.
Not pressed? Okay, just say that IA 3 of 24. This is an application filed by the appellant. Bringing on record the LRs of respondent number 4 before the writ court. That is Sri
Srinivas Murthy.
Srinivas Murthy. The council says that it was during the pendency of the writ petition that the 4th respondent had expired. And the appellants herein had filed an application for bringing the LRs of the 4th respondent on record, but the said application was disposed of. When the writ petition came to be dismissed for the reasons stated in the application, in the affidavit supporting the prayer in the application, B.G. Jayalakshmi, wife of late Srinivas Murthy, and Dr. Sanjay S., son of late Srinivas Murthy, said to be the legal heirs of the late Srinivas Murthy, are brought on record as 4A and 4B, as respondent number 4A and 4B. Let amended memo of parties be filed within 1 week. Necessary corrections be done in the memo of appeal. Full stop. On such filing, notice shall be issued
Please.
to the notice shall be issued
1 to 3 statement.
Only R.
notice shall be issued to the
4 and 5.
said respond 4A and 4B.
Yes.
We take on record so and so appears for respondent number 1, 2, and 3. You appear for 1, 2, and 3. Full stop. Okay, returnable on IA 2 of 24 is not pressed by the learner counsel for the appellant. Appellants. Have you filed the second set?
Yes, my lord, we have
When
filed.
did you file? Second set of this IA 3. So you don't carry out the objection. That's a difficulty,
Please.
you know.
Please, my lord, I will verify, I will
Do it.
verify.
We have passed an order. When will you do it?
Tomorrow, my lord.
You will do it today.
Please, my lord.
Just give it to the court master. We have to have that order, the second application.
Second set of this one.
Is it there?
IA.
No. Memo.
Just take it, ma'am. He will. Just take it. He will bring it on the.
Fine.
25-4, serial number 9. Shri Lingaraj.
In this case, my lord,
Yes.
I'd like to appear for appellant, my lord. So far as I filed memo, my lord, seeking dispensation of notice to respondent number 1 and 2, my lord, Before trial court also, my lord, they are absent, my lord. Once notice.
Appear for whom?
Subsequent purchase. Component number 1 and 2 are the owners of the property. Therefore, my lord, notice to those component.
My lord, before is the order passed by the trial court on order 39, rule 1 and 2, my lord. Therefore, my lord, the prayer is against the respondent number 3.
No, but how would you seek here against him? If they are not parties?
Then, my lord, I filed appropriate application, my lord, for substantial service. I take notice, my lord, that was returned, my lord,
Saying,
unserved. Address not found,
what was the report?
first time.
What was the report on 1 and 2? Left. They have left.
Even before trial court also, order shows that they are absent, my lord.
He was not a party.
He is
For the
party
tr-
before trial court, my lord.
You appear?
He appeared. Relief is against respondent number 3. So for order 39, 1 and 2.
They are ex parte, the other two, 1 and 2.
1 and 2 expert. They are the owner of the property. I am the agreement holder. My lord, substantial payment had been received from the appellant, my lord. Thereafter, they executed the sale deed. Now, I filed the suit for specific performance. My lord, initially, the trial court has granted the interim order, ex parte interim order. Later, my lord, the trial court, after appearance of the defendant number 3, my lord, interim order has been vacated by saying that he is the bona fide purchaser. My lord,
What is
without
the-
deciding the suit, my lord, the presumption of the trial court is, my lord, incorrect. My lord, without the trial, my lord. Only and,
No, but what is the interim order you are seeking?
my lord, I am seeking, my lord, not to alienate the property.
That would be directed against him.
Please,
But how would you get the final relief?
my lord, no, that was vacated. Now this court,
Cannot understand. Now, what is the suit for? Specific performance?
suit for specific,
Against whom?
against, my lord, defendant number 1 and 2.
They are not appearing, they have left.
My lord,
Can that be
There-
against him?
there, my lord, otherwise, my lord, I will take, my lord, file necessary application to,
You must look into
please,
that.
my lord, please.
Even if they are through publication, it's affected. But that
But-
specific performance can be against him.
Before trial court, my lord, I do that exercise, my lord. Before this court, my lord, only relief against defendant number 3. Therefore, my lord, let them maintain.
Tell us one thing in these facts. No, tell us one thing, whatever it's worth. Surely may not be specific performance. Surely there can be an order of restraint. Why you?
Unregistered agreement of sale. Was executed on 26/2/2020.
What is it?
Lapse of 3 years, my lord, the sale deed has been executed. I am the bona fide purchaser. My lord, therefore, my lord, this relief is only against defendant number 1 and 2.
For specific performance.
For specific performance.
We are only on 39, 1 and 2.
39, 1 and 2, my lord, the court has vacated the interim order granted earlier. There was a restriction also not to eliminate the property. That has
See,
been-
tell us one thing very well in the facts, possibly that what weighed with the trial court was this. The prayer of specific performance cannot be granted in the facts. Okay. So if it is cannot be granted, what can be granted to you is damages or the refund
No,
of the
I'm-
money.
My lord, the agreement stands, my lord, because that even Supreme Court also held that even unregistered agreement can be enforceable. My lord, Supreme Court, my lord, in year 2023 SC 257, Supreme Court held that, my lord, even unregistered.
Forget it. We are
Please.
saying whatever is that trial court will, we are only saying this. 1, 2 not appearing, they have left.
My lord, insofar as appearance concerned, my lord, now that stage is not yet completed before.
Very well. Then insofar as this appeal is concerned, how will now this?
My lord, now I file necessary application, my lord,
For what?
for substantial service, my lord.
Then they were not there, they are not there. Will it not be appropriate for you to think over that you file an application, maybe 520 or whatever you want to file
Please.
before the trial court, or trial court has proceeded ex parte against them? No. There, and effect a substituted service, maybe they will be proceeded ex parte. Then you proceed insofar as the interim order is concerned. That interim order was not to alienate the property.
Please, ma'am. For,
Now, whether you must look into it, whether that prayer can be granted, anything relatable to that prayer for specific performance can be granted in the absence of 1 and 2.
my lord, now the burden is on,
How will you seek a specific performance against him? Unless and until you get an order against 1 and 2, you can't seek against him.
my lord, if I approve the agreement, my lord, then undoubtedly, my lord, I will get the,
Against whom? Against whom?
against the owner of the property. My lord.
He is, according to him, he is a subsequent purchaser.
My lord, now,
See, that may way
My
with the
lord,
court also say
my-
that 1 and 2 are not there, whether he is a purchase, now whether you must think over it. Why this appeal?
my lord, now the interim order is,
There's one thing,
My lord.
tell her, do you intend to dispose of?
my lord, interim order is there, my lord. Let the interim order should be continue, my lord, till disposal of the suit, my lord.
But why should he be burdened with that interim order?
My lord, otherwise, my lord, if the property is alienated, my lord, again, third party interest had been created.
Very
Now we have to,
We appreciate that.
we have to implement the third person, my lord.
You must look into it. Will you get such a relief when 1 and 2 are not there? Whatever maximum you get is maybe the refund with interest
My lord, till
or
such,
some damages.
my lord, my lord, till such that, my lord, it cannot be, the property cannot be transferable, my lord.
Will not be.
Please, my lord.
But what will you get in your suit? We want to know. 1 and 2 are not appearing.
That, my lord,
What will you get? That's what we are putting. Will you get specific performance?
my lord, in the event, my lord, if I prove the if I prove the agreement, my lord, if I prove the agreement, undoubtedly, I will get the relief of specific performance, my lord.
How would that be implemented? Against whom? 1 and 2 need to?
My lord, virtually, my lord, the sale deed become illegal, my lord. Court should execute the sale deed, my lord. Yes, if that say agreement is justified, the sale deed is illegal, then court,
Very well. Okay, you
No.
work it out. Okay. So what do you say? Do you intend to?
I filed an application for vacating the disposition, my lord, rightly the court holding that the agreement of sale is an unregistered agreement of sale executed on 20th of February 2020. After lapse of 3 years, my lord, that is after lapse of limitation period, my lord, that sale deed, registered sale deed is executed in my favor. Holding that, my lord, the trial court has rightly vacated the interim order.
no, that is not acceptable. There is several conditions in the agreement. There is performance is required to be fulfilled in agreement. Therefore, my lord, undoubtedly I will prove the agreement, my lord.
Okay.
You cannot say
So-
only mere is the,
Will you serve 1 and 2 publication?
my lord, at this stage, my lord, the relief is against,
We don't know.
then, my lord, I will take a chance, my lord. I'll file necessary application. Interim order is there, my lord. Finally extend the interim order.
Just,
Grant 2 weeks time, my lord.
just say this 1 and 2. This is a memo filed for dispensation of notice to R1 and 2. You don't want to press this? You will not press this. Dispensation.
Dispensation, my lord. Why I filed, my lord? They are absent people.
No, you
I am
won't-
not pressed, my lord.
Obviously, you will not file, you will file an application under 520.
I'm not
File
pressed,
it.
my lord. I'm not pressed.
If the learner counsel for the appellant says he shall not press this memo as the appellant intends to file an application under order 5 rule 20 for substituted service on respondent number 1 and 2. At his request, re-notify.
My lord, one more thing, my lord, is the agriculture property, my lord. Now, commercial suit, before trial court, my lord, insisted to file commercial suit, my lord. Now, commercial suit had been filed, my lord. Now it's required to be go.
We don't know. You will make your submission before the trial court. We are in an appeal.
Please,
We will not determine what is to be done there. You will make submission on that.
Kindly extend the
Before
interim order.
There will be the interim order dated 30/9/24 shall continue till the next date of hearing. We are fixing a date.
26/3,
Please, my lord.
Next,
serial number 10,
let fresh notice be issued for service on respondent. Returnable on. Let fresh notice be issued on, for service on respondent, returnable on. Hmm? Has been? Acha, just say that. Notice, let service report on respondent number 1 be. You appear for whom?
I'm sorry, my lord, I'm sorry.
Be filed on the next date of hearing.
10/3,
The report has to come. Report is
Please.
awaited.
Please.
11,
Lord, I appear for the, give it to respond. I appear for the appellant. 4 weeks time I grant, I file the paper books, my lord, where the translation is required, the documents are required.
As far as the R2 is concerned, my lord.
R2 IPF, I filed wakalat on 9th January.
Your lordship may kindly dispense with, I don't think the paper book is necessary because only the evidence matter to be disposed of on the evidence itself. And I have a copy of the evidence.
You appear for R2?
Please, ma'am.
You
I
for
filed
1?
wakalat. One.
Yes.
We're filing of paper book for 4 weeks time I grant, I'll file the paper book.
Now, what is the issue?
It's a suit for declaration, suit came to be decreed.
Who came into degree, my lord, and it is the contesting respondent, my lord, has admitted that his saying it is said subsequent. And he has in the meanwhile, what he has done is he has entered the property, he's demolished my compound wall, he's put up construction, illegal construction, it's all part of the record. Lord,
Now, where-
absolute injustice has been done to my client. Absolute injustice.
No, but that's the direction of the court for demolishing.
Yes, I mean, the court has directed, I mean, the thing is, he has trespassed with the property. He has, taken law.
And where
into
the-
his hands.
Who has done it?
The.
Appellant.
The appellant. First respondent before the.
Now,
trial.
where
You are the defendant, first defendant.
Yes. Well, second defendant has executed a sale deed in favor of me. I am in the position of the day one of the sale deed executed. Where,
2009 property where he has
But-
admitted.
well,
The
Bab-
first defendant has admitted that in his property, his state is second. Can I read the relevant portion, my lord? Can I read the relevant portion of the cross examination?
a sale deed has been executed to me. Thereafter, rectification has been executed to the different number,
Yes,
plaintiff.
Is there any stay here?
Yeah, is there, madam. Status quo order is there. But the matter is admitted.
No,
As
you-
per
you
order
file
dated.
You file your paper books, we'll
Yes.
hear it. We'll set out for here.
29/11/2024.
Not necessarily, just evidence on this matter could be disposed of.
All the documents which were there, exhibited documents are here, yes or no?
No,
May
madam.
not be necessary. That's what my.
That's your perception, we don't know. See, let's be very clear.
Lordship, kindly fix the date, my lord, so that.
We'll fix a date. File your paper book. It
Yes.
will be convenient for the court, maybe for you also.
4 weeks time is granted, this is not. Earlier, it was a direct five paper, not done. Anyway.
No, it's not there.
We will bind him as a last opportunity.
The
Just
first
say,
time it's coming for paper book.
just say so and so. Here's for the respondent number 2. Just say that paper books be filed within how much time?
6 weeks.
Why 6 weeks?
Kannada translation is there, more documents are there.
Paper books with the Kannada, English translation of the Kannada document shall be filed within 4 weeks. The copies to the counsel appearing for the respondents through e-filing. Okay? Through e-filing within 4 weeks from today.
6 weeks.
Appeal for hearing on. Date, give a date.
19/3,
Interim order dated 13/12/24 shall continue till the next date of hearing.
6 weeks may granted once problem.
All right, well, 4 weeks are enough. Next.
serial number 19/3, sir. Sir, 19/3 date. Serial number 12,
Just for the applicant lots.
the
Lots is directed as notes to file notes written submission lots along with the lots, the authorities.
Yes, you are ready?
Notes kindly grant me a week's accommodation notes, I'll file
What?
notes. Notes, file the notes, the synopsis and written submission.
Your lordships are directed as my lords on the last date of hearing.
But somehow notes, by oversight notes, we are not able to.
Submissions, you have filed it?
No, my lords.
Submissions be filed by the counsel for the parties within 6 weeks, list on.
Great lords.
Through e-filing,
Lots,
you will do the e-filing.
Please, ma'am.
25-3,
public lords.
serial number 13. Yes, ma'am.
Last occasion, my lord, here undertaken to file wakalat for R2. Then, my lord, then I think, my lord. Then my-
Wakalat has been filed by 2 and 3 both.
Yes, both I've got it from Korea and I filed it, my lords. I've already filed. I
Yes,
undertook and I filed.
My
yes,
lord, there's a delay, my lord, of 2 days, my lord, by the time.
that we will condone it. Then what is your case on merit?
Or can it be passed over, my lord? I will just finish. Ready.
Just say this, delay of 32 days in filing IA 1 of 19. Is it 19 when MSA is 20?
Sir, 32 days delays.
No, that is,
IA is 19,
Years of 19, my lord, yes.
but MS is 20.
MSA is 20. Delay of 32 days in filing, the appeal is condoned. Unless the appeal for hearing on, just give it in February 2nd week.
But what happened, my lord, is that it was filed in 19, but by the time it was numbered, it was 2020. So it
Should be 20.
20. Yes.
It is registered, it
Yes,
should be that
20,
year,
20.
not the filing year. Okay, very well, let's not go into it. We will still show 1 of 19 because that's the number we have.
Yes.
We'll go further. Someone's just say that as the respondents 2 and 3 are represented by the councils who have filed their wakalat, IA 2 of 19, IA 1 of 24 has become infructuous and is disposed of as such. Okay, MSA and 2 of 19, just list it in February for arguments, for hearing.
Can I request my lords on 19th, my lords, if it is okay?
19 February.
Because they have possession of, yes, my lords, they have possession of my flat.
Okay.
Nothing remains. My whole property for 7 years.
Let's see, have it 19 February.
14. Serial number 14. Ma'am.
Kindly pass over, my lord.
Pass over.
On with regard to that limitation. With regard to the limitation beyond arbitration, not commercial court appeal.
34,
Yes, 37 and 13 of the Commercial Courts Act, my lord, the Honorable Supreme Court.
6090, yeah.
Yes, my lord. So earlier, my lord, the Honorable Supreme Court, headed by Justice Rohinton Nariman, my lord, said it cannot be condoned. Subsequently, sitting in a 3 judges bench, my lord, but there also, my lord, they say that long delay of 70 days, 75 days, my lord.
No, that their judgment is a delay which is akin to 34-2 must also govern an appeal under 37.
Yes,
That's right.
that's,
We'll pass over.
please.
15.
For the appellants, my lord. My lord, in the, my
First
lord,
respondent, my lord.
Yes.
my lord, in the title suit, we have not been made parties, though we were necessary parties. We had no knowledge of the judgment and decrees. But our rights have been greatly prejudiced in this appeal that we have filed because we, if your lordship may permit, I would argue on the merits. Now,
You are
my
ready
lord,
now, we'll pass over. Just pass over.
My lord.
We'll come back. Yes,
Pass over.
next.
16. Sri Hari. 16.
Yes,
Hearing for the appellant in this matter, my lords. Lord's last occasion, my lords, your lordships.
yes. What are your instructions?
Lords, he needs little more time, my lords, because
For what?
for repaying the money, my lords, that he has.
In terms of the decree?
Lords, that
You are
also.
bound by the statement before the writ court. How
Please.
can you now come out? So, no, we say nothing. You are bound by the statement.
Please, my
In
lords.
view of the statement, you will withdraw this. See, we will not reiterate that order which is there. That's binding on you. You will Surely this appeal in view of that statement may not survive.
Please, Millards.
So what do you
Okay.
want?
If this could be adjourned for a short accommodation, Millards, because he will.
Doesn't make any difference, ma'am. That order will bind. So we don't, let there be another no further order. If you want to withdraw it in view of that order.
I do not have the instructions to.
You take
withdraw.
instruction, we'll pass over. Pass over. Next.
17,
Case of for appellant, my lordships. My lordships, IA number 1/25 for permission to file affidavit to reporting the death of R1 and R2.
R3, R4 are the legal hairs
Yes, my
of
lordship.
1 and 2.
R3 and 4 is the legal heirs of R1 and R2.
Yes.
Are there any other legal hairs?
No legal heirs. It's only two female legal heirs.
You file, we will say so. You will possibly file an amended memo.
I filed affidavit and IA, my lordship. R1 is expired on 25/11/2022, my lordship. R2 is expired on 23/3/2023, my lordship.
Who is Gayatri Devi? R5.
R5 is the one of the,
She is not
Joint
related to
family
them.
member.
She is not related to them.
it's not related, my lordship.
You appear for whom?
I appear for R5 and R6.
R5 and R6. Just see this, and affidavit has been filed by the counsel for the appellant. Is that on record? Ma'am? Affidavit?
My lordship, IA number 1 and IA number 2 is the not to alienate and not to change of the shoot schedule property, nature of the shoot schedule property, my lordship. These respondents are trying to alienate the shoot schedule property and change of the nature of the shoot schedule property. They are formed the layout, my lordship.
Has filed an affidavit wherein in paragraph 3 of the said affidavit, the following has been stated, or you just say this, the counsel for the appellant has filed, just cut, has filed an application on 16/1/2025. Why is this not numbered, man? With the following prayer, it's not numbered. It's a 1/25. In support of the prayer made in the application, an affidavit has been filed. Paragraph 3 thereof reads as under. Full stop. The learned counsel for the appellant states that the respondents 1 and 2 have been survived by respondent 3 and 4 as the legal heirs. Full stop. If that be so, respondent 3 and 4 being already on record, shall also be shown as the legal heirs of respondent number 1 and 2. In that regard, let amended memo of parties be filed and necessary correction in the memo be carried out. Application disposed of. The so-and-so appears for 5 and 6 now. The learned counsel for the appellant presses for stay now. Presses the stay application being, what is TI? Presses application 1 of 24 and 2 of 24.
Yes, my lordship, for not only need the mutual property and not to
The
change.
so-and-so counsel appearing for, just say that, is anyone appearing for,
Yes, my lordship,
the, for legal has 4 and 5,
4 and 5 is,
No, no, 5 and 6.
3 and 4.
3 and 4 is up here.
They have been served, ma'am.
Wakalat is filed by advocate.
No, have they been served? Mr. Siddharaj is appearing.
Yes.
Just say that we find that there is no appearance for 3 and 4. Though Mr. Siddharaju, MS advocate, has filed his appearance for them. First up. Now, the counsel for respondent 4 and 5 and 6 seeks time to file objections to the application. Same be filed within 2 weeks. This is the application.
Humble request, my lordship, this the matter is most urgent. I already separate the copy on 17 December.
What is your
Served on the last date or then after.
17th December itself, my lordship. Last date of occasion.
Agreement was made by.
You file your objections. When will you file? 2 weeks. We'll have it after 2 weeks.
Short accommodation,
You are doing it. Yeah, after 2 weeks.
published. my lordship.
13-2.
Humble request, my lordship, this is a date maybe, my lordship. Date
13-2, sir.
Okay.
Till number 18, Narasimha Prasad.
I beg to appear for the appellant, please. Suit for recovery of money, it's a defendant's appeal.
You ready?
There is a delay of 15 days in filing.
We'll condone it. We'll hear it. Pass over. Next.
19. Till number 19, medical staff.
So you are appealing just this.
Defendant's appeal, my lord,
Hmm.
in a suit for recovery of money, the defendant did
Just
not.
say issue notice. Let's see the file, man. How much is the delay? 12 days.
12 days.
Just say on the delay also. So you deposit,
Lord, yes, I am in fact holding a DD for a little more than 50%. When the amount was due at that time, it was 50%. I'm holding, if the DD can be accepted by this honorable court.
75%.
Then my lord, may I just present this DD and I'll make good the balance with a separate DD.
In whose name?
This is a DD in favor of the Registrar General, High Court.
It was prepared beforehand. You-
Well, that's a
75%, Mr.
Defendant is a public sector unit. We had advised them that this is a suit for recovery, some deposit will be required. On our advice, they had kept a DD ready.
Yeah, no, I'll deposit 75.
I will, I have no difficulty.
We'll give you time,
Very well. I will deposit this and then make good the rest with the balance.
whatever you feel like. Say nothing. We'll
Very-
pay 75%. Just say that's subject to the appellant depositing appellants, depositing 75% of the decretal amount computed as of today. Within 6 weeks.
Yes.
Okay, with the Registrar General of this court, there shall be a stay of the impugned judgment decree dated 2nd August 2024, passed in commercial OS number 49 of 2024 till the next date of hearing. The amount to be deposited by the appellants shall be invested in an interest-bearing FDR of a nationalized bank till with periodical renewals till further orders. Okay. Delay, just say that for the reasons stated in the application, in the affidavit supporting the prayer for condonation of delay of 12 days, the delay is condoned. Application disposed of. Then this order.
Trial court records may be called for.
Let the trial court record be requisitioned before the next date of hearing.
Great.
16-4,
Next.
till number 20, Kulkarni. 20.
Yes, Mr. Kulkarni. Come.
Minus 20 and 37 are connected.
Yes, both are connected. Yes, what do you say?
This, as far as 20 is concerned, this dispensation is asked for because in that 37 I have produced all them. In serial number 37 petition, the OA of that was made part of this.
Doesn't make any difference. We'll just go, what is the challenge, Mr. Kulkarni?
Milas, 37 you are lost in kindly take so that it will be easier for me to.
Just give us 37.
Last, they all belong to machinist trade in 515 Army or base workshop at Bangalore. Milas, this trade-wise seniority was counted for the next grade of promotion. Until 1987, recruitment rules was there in force.
When did you become this machinist or mechanist? What is that post?
Machinist.
Machinist.
Yes, ma'am.
When did you become machinist? Before 87.
Before 85.
Now, what is the next post?
Next is actually in 2003, grade restructuring took place, according to which skilled and highly skilled and craftsmen were the created posts under that.
Skilled or highly skilled?
Skilled, highly skilled, and craftsman. Skilled to highly skilled is treated as a promotion.
Skilled to highly skilled, but were you skilled or were you skilled?
I was initially skilled as a machinist,
Okay,
basically
you are a
skilled.
Okay, okay.
Skilled to highly skilled according to this 2003 restructuring situation. Plus highly skilled contained two grades, HS1 and HS2. Until 2010, this HS1 and HS2 were not separated. They were carrying the same pay scale under the 1996 pay scales. Plus this HS2 carries 2,400 grade pay from 1,900 grade pay. I initially carried 1,900 grade pay as per 6th pay commission. Earlier it was corresponding previous scale.
As what? 1900 as a machinist or as a skilled?
As a machinist.
As a skilled?
No, unskilled. Basically, basic 1900 is the basic scale. That was 3050 or something of the kind in the earlier stages. 4,000 to 6,000 became the corresponding pay scale of the highly skilled as per 2003 restructuring cadre. Actually, there was a trade test prescribed and we all passed the trade test, and then promotion orders were not issued until the new recruitment rules of 1/1/2006 came into force.
To the highly skilled?
No, the new recruitment rules of the entire cadre was changed there. The new recruitment rules came under SRO 28 of 2006 or something of the kind. In that, different yardsticks were prescribed. All of us came to be promoted in accordance with the recruitment rules of 1987, prior to coming into force of 1/1/2006, 2000 new rules.
Who were promoted?
Millers?
Who were promoted?
All the petitioners before you.
They were promoted.
Promoted. The only thing is that promotion order came to be issued subsequent to 1/1/2006. In respect of the vacancies that stood there up to 1/1/2006.
No. So promoted would be, promotion will be with the order now. Once the order is issued, then you are promoted.
Yes, Millers. That order came to be issued only in 2011.
2011?
11.
From a back date?
From the back date.
What is the date of issuance of the order?
Millers, 9/3/2011.
Oh. From which date?
Millards. One minute, Millards, 271 page, your last time I kindly look at in the first value.
Yes. From 2004 and 5.
Yes, Millards.
Okay.
From 1/1/2006, actually new recruitment rules came into force from 18/2/2006. They came to be notified on 18/2/2006 under SRO 28 of 2006.
Which were the old rules?
Old rules were SRO 1 of 1988. Your last time I kindly find that old rules,
1987.
1987.
So they continued to hold the field till 2006.
Till that 18/2/2006. Plus 18/2/2000 new recruitment rules introduced a concept of merged cadres.
Come again, what did you say?
Merged cadres means machinist cadre, initial machinist cadre. Along with that, few other cadres came to be merged and they were classified as a machinists thereafter.
Under which rules?
Under 2006 rules.
So machinist was merged.
Machinist existed. Machinist existed under 87.
Yes.
Individual trade as such. Under 2006, what happened was few other trades came to be merged with the machinist trade, and all that became one machinist trade.
Okay.
After 18/2/2006, merged seniority list of this merged cadre became the basis for issuing promotions.
Promotion order on 9/3/2011.
Yeah, but Millards, what happened was when we were entitled for the under 1987 rules, when they did not extend it in spite of our being eligible for that and entitled for that, we went to the CAT in OA 500 of 2007 first.
Immediately after merger.
Because continuous process was there in that.
2000, what was the prayer in 2007?
In 2007, our promotion prayer was there relating to the vacancies existing up to 1/1/2006.
Now, what happened to that?
The tribunal, as usual, directed to make a representation and then the department to dispose of. They disposed of against us.
Which date?
That is became the subject matter of OA 500 of 2009.
Okay. You challenge that. What is the ground for rejection?
No, they did not say anything. Your recruitment process was not over by then. That's what they say.
Okay. What happened in 2009?
We challenged that issue before tribunal in OA 500 of 2009. During the pendency of that OA, they considered the prayer made in that OA 500 of 2009 and came forward with this 9/3/2011 promotion order.
What happened to 2009 OA?
OA 500 2009, during the pendency of that, authorities considered the prayer made in that OA.
And then 9/3/2011 was passed.
Yes, Malak. They produced that 9/3/2011 order. Tribunal said your OA has become infructuous, therefore we are closing that, and they closed that.
Okay.
So far, so good. Thereafter, what happened was, after this 18/2/2006 recruitment rules came into force, other cadres who came to be merged with the machinist cadre, some of them, they contended that If in the unified seniority list is operated upon, any promotions given after that 18 to 2006, our seniority will count over the petitioners according to their trade seniority initially.
Whatever is their seniority position.
Yes, my lord. Merged seniority. Tribunal, instead of going into that question, what tribunal has done in two sets of OAs filed by them, J. Sampath Kumar and others, one this thing, Prakash and others in another thing. These two cases arose before the tribunal. Tribunal said you extend par with benefit what is extended to the petitioners before your lawsuits.
To them also.
To them also. Our OA 500 of 2009 came to be closed in that manner, and our promotions were never disturbed by anybody, including the department, or that was not under challenge by anybody.
That 2011?
Yes, my lords. That order became final once and for all.
You have no grievance on that?
As far as 9/3/2011 order is concerned, I have no grievance at all.
Okay.
I am deriving the benefit out of that. This, as far as this two sets of OAs is concerned, which came to be allowed by the tribunal subsequently with reference to the merged cadre of the machinist, the petitioners belonging then merged cadre. They, against that department preferred a writ petition before this honorable court, challenging that order.
Which is that date order? What is the date of that order?
That order of tribunal's order.
That's right.
Tribunal's two sets of this thing, my lords. One is 11/4/2014 in OA 197 of 2011.
And
Filed by J. Sampath Kumar and others.
this is only one way.
And two ways.
Which is
Another way is 1520 of 1531, 1520 to 1531 of 2015. Decided by the tribunal on 27/7/2016. These two OA judgments are available before your lordships in volume 2 at 286 to 297 first OA judgment.
Okay. Now, these OAs have been filed by those people who got merged with mesh.
Yes, my lords.
What was their case?
Their case was after 18 to 2006, any promotions to be given only with reference to the merged seniority list
Okay.
coverage.
What does this court holds?
The department challenged only those two orders passed by the tribunal, where par with benefit was extended to them with the petitioner's benefit given on 9/3/2011. This honorable court, my lords, they challenged it in WP 31240 of 2015 department, and also another WP 53718 of 2016. These two writ petitions were clubbed, and a common order came to be passed by this honorable court, wherein we were not parties.
Yes.
Your lordship may kindly have a look to that judgment. It is available at Annexure A45 in the second volume. In the
What is
volume,
the
at page 343.
340?
At page 343.
Yes. What does the court holds?
After discussing your lordship, may kindly straight we go to page 359.
359.
Para 10.
Yes.
Your lordships are perusing that para 10. I will read that.
You have seen that in the.
Yes, my lord. 10 and 11, your lordship may kindly have a look.
Yes.
The resultant person is what we are facing before your losses today. Two, three times department passes orders. We were before the tribunal. And then they say that the tribunal says two times that it is only a show cause, you show the show cause there. And ultimately they pass the order seeking to implement the order passed by the Honorable Court.
That's right.
That is how what has happened is the order passed by the authority was under challenge in the latest OA before the tribunal. Tribunal has passed a negative order against us. I am before your lordships.
Now tell us, what has been challenged before the tribunal was an order passed pursuant to the order passed by this court. Are we right?
Now, in the meanwhile, we also approached this Honorable Court
By way of?
by way of once the authority issued they classified it as a show cause notice. Tribunal said it's only show cause notice, therefore we don't want to interfere. That order we challenged before the Honorable High Court. We brought to the notice of the Honorable High Court the factum of this paragraph 10 and 11, and then said that the 10 and 11 factum, whatever it is out of the 500 of 2009 OA. The decree that is given there is untouched. This observation will not unseat us is the contention taken in that writ petition.
No, but that OA was not decided, no? 2009 became infructuous.
No, my submission to your lordship is this: infructuous because of their own action.
Because of the order.
Yes, my lord.
Okay.
That order becomes the decree almost in that way. That is why OA was closed. Whether that decree earned, can that be touched in any other manner is the point involved.
This is a decree. Where is the determination of rights there, Mr. Kulkarni?
No, there was no provision for the department.
Right, you're right. You were there. They say very well, the tribunal says now they have passed this order of 9/3/2011. So your prayer for promotion has become infructuous.
There is nothing to consider. That's what they say.
Obviously, there is nothing, there is no list. If someone is agreed by 9/3/2011, they will work out their remedies. Those people who got merged, they had an issue with that promotion order. You don't have an issue. You didn't.
No, they don't have any issue on the promotion order. What they contended is, we with the merged seniority have a preferential claim and at least a par with claim with those petitioners. Therefore, extend the similar benefit to us.
Similar benefit mean like promotion.
The par with benefit, whatever is given to us in the 9/3/2011 stage.
That should be given to them.
Yes, that is what is their contention.
Okay.
What the tribunal said is, we on par with benefit we extend for the reason stated there in their orders.
Okay.
So my submission to your lordship is, if whatever the observation contained in paragraph 10 and 11, we had no opportunity to meet those observations. Without, in our absence, if the order is passed, that order is binding on us.
Now, once the show cause notice was issued to everyone, including to you?
Yes, my lord. In the recent this thing. Recently.
No, show cause, then you replied?
I replied. I said that because we were not parties there,
Yes.
it is not affecting us, one thing. Secondly, even if that observation will come in our way, we are not promoted against the vacancies occurring after 1/1/2018 to.
Your vacancies were before that day.
Yes, ma'am.
So you are not at par with, you are different from these people who have got.
That is my basic contention.
Now, what happened, then did you go to the tribunal again? Again, show cause notice?
I went to the tribunal.
What does the tribunal say? It's only a show cause notice? You reply to that.
2 times the tribunal said so, and 2 times we kept quiet. We answered that to the department. Finally, what order they say passed in that order against us? That order was in the recent way before the tribunal.
Now now on an issue of vacancies being prior to 1/1/2006, and that the recruitment or the promotion must relate back under the rules prior to 1/1/2006. What was the finding of the tribe? What is the finding of the tribe?
What the tribunal has come to the conclusion is only one finding. They say that date of consideration of the promotion is the criteria, and what rules hold the field on that day are the rules applicable.
So what is wrong in that?
My submission to your lordship is this: it is not consideration on 9/3/2011. Promotion consideration has not taken place on 9/3/2011.
When was it taken?
It was long back in 2005 onwards.
2005 onwards.
5 onwards.
What happened 2005? What is the,
Trade test was held in
what
2005.
you say, the process was initiated?
Yes,
The process
Therefore-
was initiated before 1/1/2006.
the tribunal's mistake committed is basically and prima facie, and that is dominantly affecting our case. They say that promotion exercise started in 2011 is only governed by the recruitment rules that are in force. That I think wherein your lordships are required to consider whether that stand taken is correct or not.
The trade test was under the old rules.
Yes, my lords.
Just say issue notice.
Our promotion orders are to be saved now until they, because hitherto we are saved.
No, no, 9/3/2000. Are you working on a higher post?
Yes, my lord. That is also, I have brought that, still unaffected.
Was there any stay before the tribunal?
Its tribunal only said it is outcome, it's subject to outcome of the OA.
But you were not reverted.
Not reverted. Up to December end, I have drawn the salary in the higher grade only.
But tell us one thing, Mr. Kulkarni. Now, this is something which you need to answer.
Yes, my lord.
All action have been taken, the show cause notice pursuant to the orders of this court.
They claim so.
No,
They claim so.
No, 1 minute, please. If we have to put it to you,
Yes, my lord.
the show cause notice was pursuant to the orders passed by this court, what would be your reply?
My submission to your lordship is that observation made, the passing observation made in para 10 and 11 is in support of the judgment ultimately passed by this honorable court with reference to the 2 orders under challenge. Those 2 orders are not our orders. Your lordship get that there. The paragraph 10 and 11 observations are only in order to effect their judgment with reference to quashing of those orders given in those 2 ways, subsequent 2 ways.
Saying that the promotion must be based on the merged, their seniority in the merged cadre.
Yes, it is with reference to them.
No, yeah, right. When are they claiming promotion from? From which date they claim the promotion from?
Their all promotions are after 1/1/2006.
Issue notice. So you said you are not you are not similarly placed. You are in a different league.
That is the basic thing which I am forwarding my contention.
Okay, issue notice.
My lords, your lordship may this kindly see the.
Where is the order of the tribunal saying subject to outcome?
Initially only that is passed that your lordship may take it. I have only argued that matter.
Where is your stay application?
Here in this case, my lords, before your lordships, the interim prayer will be part of the writ petition. Your lordship may kindly see page 19.
Just say this. Mr. Kulkarni has pressed the interim relief, seeking the stay of the order passed by the tribunal. Now, what action they have taken after the tribunal has dismissed it?
Nothing, my lords.
Mr. Kulkarni states that after the dismissal of the OA filed by the petitioners herein, no further action has been taken by the official respondents reverting the petitioner or changing the date of promotion. Your OA has been dismissed. What would be the follow-up action
follow-up action is they will review, we may not get promotion at all.
Oh, that is also the position,
That may be possibility because merged seniority.
or you will come down.
Yes, my lords.
States that no further action has been taken. He states that, he do state fairly that, during the pendency of the OA, in the OA, the tribunal, the petitioners herein had sought an interim relief. The tribunal has directed that any further action to be taken by the official respondent shall be subject to the outcome of the OA.
No further action was taken by them.
And no further action was taken by the official respondents. Full stop. If that be so, comma, on the prayer for interim relief, it is stated any further action taken by the official respondents, qua the petitioners herein, comma, shall be subject to the outcome of the writ petition. Both the writ petitions,
Yes, ma'am.
make a common order.
I am grateful to.
Next.
Day before yesterday, I moved this matter and your lordships were kind enough to allow me today.
Next. Off. What is dispensation of what? Exactly, what do they want? Dispensation. Just say that this is an application filed by the petitioner seeking dispensation of production of annexure A2. That is copy of OA 170/316/2023, along with its annexures. So the prayer as made in the application is granted as of now. Okay, application disposed of. Come.
21, serial number 21.
Respondent.
Yes, ma'am.
Speaks a commission order. Council on record, my lord, is inconvenience.
Pardon?
Council on record is inconvenience, my lord, today, my lord. I informed the petitioner council also, my lord. We have taken up my next week, my lord.
What is the difficulty?
Some personal inconvenience, my lord. He has got some afternoon hospitalization.
Just we'll pass over, let the council come.
I informed also, my lord.
She has no objection
No, she has.
at the request of council for the respondent number 1.
Please.
Let's adjourn to.
3-2.
Oh.
Serial number 22. Next,
This is an appeal under section.
With the other matter, no, separate.
I'm sorry, bro.
There is another matter.
Yes, members. That is item number 3.
uh,
The issue is different, members. The parties are the same,
arising
different,
from the same contract.
different contracts, different packages of bank agreement.
Okay. No, I think we may be, no,
Item number 3.
okay, it's all.
which- yes.
That's also parties are same, Mr. Kamu.
Yes.
Maybe different. Okay. Yes.
This is an appeal under section 37 of the Arbitration and Conciliation Act. The short point, my lords, which arises for consideration is whether an exclusion clause is enforceable and are there exceptions to the rule. In a nutshell, my lords, the contract relates to the construction of 3 stations of Bangalore Metro. The contract provides that even if BMRCL is responsible for the damages, for the delay, no compensation shall be payable by them. The arbitral tribunal notwithstanding this clause, considers the decision of the Honorable Supreme Court in Sarvesh Chopra and grants delay damages for 50% of the time period, holding that they are responsible for 50% of the delays. Against this, they file a petition under Section 34. The commercial court sets aside the award to this extent on the basis that the observations in Sarvesh Chopra are only obiter, and that the judgment of the Honorable Supreme Court in Vig Brothers and Ramnath would hold the fort. So the issues that arise for your lordship's kind consideration are, firstly, given that the clauses have been considered, the judgment in Sarvesh Chopra and the judgment cited by them were all considered by the tribunal. Could the Section 34 court have gone into the issue at all? Assuming that it could have, would it be right to state that the observations in Sarvesh Chopra are only obiter? And thirdly, and in the alternative, would such a clause be valid at all? Would it not fall foul of Section 73 and 55 of the Contract Act, and hence be void on the basis of Section 23?
Did you challenge that provision?
My lord, the argument was raised specifically before the tribunal. The tribunal notes it, but the tribunal then holds that since they are going on the basis of Sarvesh Chopra, they are not considering it.
The argument raising will not suffice, no? There should be something more.
We did not seek a declaration before, that the clause is
So
void.
you will fall back upon your first argument.
On the first argument, my lords, and I think even on this, my lords, I think if since it's a point of law, there's one precedent of the Honorable Delhi High Court, my lords, where despite it not being specifically challenged, the issue was gone into at the 31st.
Provision of law in that sense, it's in a provision in the contract. They may have some justification. Did they? And surely they had not given the justification for that particular clause. So they had no opportunity to even meet. In that sense, possibility cannot be said to be a pure a question.
That's only my alternative, my lord. My primary submission still is that Sarvesh Chopra today has been subsequently relied upon by a 3-judge bench in Assam State Electricity Board, and therefore is a position of law.
Subsequent to those two judgments in Vig Brothers and
subsequent to Vig Brothers, Ramnath and Sarvesh Chopra is a judgment in Assam State Electricity Board, where
there would be many judgments which must have relied upon Sarvesh Chopra. There are many judgments.
Many High Court judgments.
Many High Court judgments.
Many High Court.
Which is the latest, which refers to Sarvesh Chopra and agrees with it. And possibly disagrees with, may not be disagreed with, maybe distinguish the Vig Brothers and the other one. Which is the latest?
The latest Supreme Court judgment is Assam State Electricity Board, which is a 3-judge bench, which cites Sarvesh Chopra, but doesn't go into the other judgments. So I don't think there is any Supreme Court judgment which considers both sides of the judgment. And in my respectful submission would be in all the judgments cited by the respondent in this case, they were all cases where the tribunal ignored the clause. Today, in light of the amended Section 28(3), the tribunal considers the clause, that would suffice. All those judgments were cases where the tribunal entirely ignored the clause and granted compensation.
But we have one set of judgments also where the contract specifically says something that need to be given effect to.
Yes.
That's right. What does the contract says in your case?
Contract contains a bar.
There is a bar.
There is a bar.
If there is a bar, could that have been given?
That's the issue that arose.
34 must have considered this only.
Yes, my lords.
What is your take?
My lords, in my respectful submission, even if there is a bar, compensation can be granted.
Under invoking 28(2) or 28?
No, my lords, on the basis of the principle exception set out in Sarvesh Chopra's case.
Show us that.
Yes. So I may just pass on the case law compilation. at page 142. At page 142, my lords, is the judgment in Sarvesh Chopra. The clause in question,
63.
sorry, my lords,
63.
142 minutes.
Okay.
The clause in question is at paragraph 4 at page 146. The clause reads, no material price variation or wage escalation on any account whatsoever and compensation for force majeure, etc. shall be payable under this contract. No claim whatsoever will be entertained by the railways on account of any delay or hold up of the works arising out of delay in supply of drawings, changes, modifications, alterations, additions, omissions in the site layout plan or detailed drawings or designs, and or late supply of such materials as are required to be arranged by the railways or due to any other factor on railway accounts. 21.5, no claim for idle labor and or idle machinery on any account will be entertained. Similarly, no claim shall be entertained for business loss or any such loss. The principles, my lords, are set out from paragraph 15 onwards at page 152. In our country, question of delay in performance of the contract is governed by sections 55 and 56 of the Indian Contract Act. If there is an abnormal rise in prices of material and labor, it may frustrate the contract and then the innocent party need not perform the contract. So also, if time is of the essence of the contract, failure of the employer to perform a mutual obligation would enable the contractor to avoid the contract as the contract becomes voidable at his option. Where time is of the essence of an obligation, Chitti on contract states, a failure to perform by the stipulated time will entitle the innocent party to A, terminate performance of the contract and thereby put an end to all the primary obligations of both parties remaining unperformed, and B, claim damages from the contract breaker on the basis that he has committed a fundamental breach of the contract, a breach going to the root of the contract, depriving the innocent party of the benefit of the contract, the damages for the loss of the whole transaction. If instead of avoiding the contract, the contractor accepts the belated performance of reciprocal obligations on the part of the employer, the innocent party, that is the contractor, cannot claim compensation for any loss occasioned by the non-performance of the reciprocal promise by the employer at the time agreed, unless at the time of such acceptance, he gives notice to the promisor of his intention to do so. Thus, it appears that under the Indian law, in spite of there being a contract between the parties, whereunder the contractor has undertaken not to make any claim for delay in performance of the contract occasioned by an act of the employer, still a claim would be entertainable in one of the following situations. One, if the contractor repudiates the contract exercising his right to do so under section 55 of the Contract Act. Two, the employer gives an extension of time either by entering into supplemental agreement or by making it clear that escalation of rates or compensation for delay would be permissible. Three, and this is what the tribunal relies upon, if the contractor makes it clear that escalation of rates or compensation for delay.
Just one, Mr. Kamath, you are there in this one.
Yes, yes. No.
We can hear it.
I had appeared in the arbitration as well.
Okay,
I've been there in this matter right from the.
so we can hear it. Go ahead.
Yes. So three, if the contractor makes it clear.
I'm sorry, afternoon, there is some difficulty.
We'll see it. We'll see it.
Three, if the contractor makes it clear that escalation of rates or compensation for delay shall have to be made by the employer and the employer accepts performance by the contractor in spite of delay and such notice by the contractor putting the employer on terms. Well, my lords, even if there is a clause that bars the grant of delay damages can be granted if the contractor puts the employer on terms that it intends to claim compensation and the employer accepts performance thereof. This is the exception that is carved out in Sarvesh Chopra. May I straight away, my lords, take your lordships to the arbitral award that considers this exception, considers.
Who has put the conditions here?
It is a,
The whole, they have put the condition.
it is their condition.
What do they say?
Yes, no, I will straight away come to the clauses.
It can't be said our condition. It's a, both parties
It's a
have
contract.
agreed. It's
Yes.
an agreement between two parties. It is not our condition. In the sense, not one party. Both parties have agreed and decided this is the condition.
That's right.
It is part of the contract. It is their standard contract. It's at volume 2.
Which you have also agreed.
We have also agreed. I'm not disputing, which we have also agreed. Volume 2, page 4.
See, you know, this was, the Sarvesh Chopra, everything was in the previous, I think, line of judgments, you know, you have signed on the dotted lines, you know, all those things, you are bound by this, everything. But the fact remains, there are set of judgments also. And ultimately, the arbitrator is also a creature of a contract between the parties. He is bound by the terms of the contract. The parties have agreed a particular, the contract should be in a particular manner. So anything which cannot be, which is contrary to the contract cannot be argued nor can be claimed by any of the parties. Once you have agreed for that. That line of judgments are also there. You're right.
Yes, ma'am. My lords, there are the line of judgments starting from Ramalinga Raju till Vig Brothers and Ramnath.
Well, much thereafter, so many are there.
Subject to correction, my lords, the last Supreme Court judgment is Vig Brothers.
2010.
2010.
No, we are on a proposition, not on this Sarvesh Chopra. We are on a proposition where the contract bars a particular claim or a particular claim based on the contract only. The arbitrator cannot give it. If he goes contrary to the contract, he is misconducting. It's a misconduct on his part.
My lords, the subject to correction, my lords, learned senior may correct me if I'm wrong. The last judgment on that point is Vig Brothers. But after.
Forget, no, we are on a different proposition.
Yes.
Vig Brothers may be considering Sarvesh Chopra and then coming to a conclusion. No. Mind it, this would be, you will find n number of judgments, even the latest judgments also you will find it. The arbitrator must confine himself to the terms of contract. That, right? On that proposition also you have to address.
Certainly, my lord, and there, my lord, straight away to go to that point, there was a, if I may draw your lordship's kind attention, my lords, to the amendment to section 28(3) in 2015.
Yes.
The old provision read,
See, what is the heading of 28? Read that.
28 is rules applicable to substance of the dispute. The 28(3) prior to the amendment. Give me a minute.
That's more, possibly will not help you. 28(3).
No, no, 28(3) was in absolute terms prior to 2015. It provided that the arbitral tribunal shall be bound by the terms of the contract.
But are you saying trade usages?
It has been amended to say shall take into account.
That's why it says.
So it dilutes it from being shall be bound, which means that no departure can be made whatsoever, to a situation where appropriate, a departure can be made so long as the contract is taken into account.
So what does it say? And it will take into consideration the terms of contract and trade usages applicable to the transaction.
I bought on.
Possibly gives a scope for you to argue these are all trade usages, possibly.
I bought on.
Very good.
And in my lords, all the judgments under the old regime, culminating in Vig Brothers, were all pre-amendment. So there, the arbitrator was strictly bound by the terms of the contract. They could not deviate from it. Now that extra leeway is there.
Will the trade usages becomes relevant? Let's assume a situation, this clause was not there.
Yeah.
Okay. and they argue, look here, it cannot be given, there is no stipulation. You will argue, no, trade usages, the claim the claim which has been made, or the delay which has occurred, or something like that, is the day-to-day, the manner in which the contracts are being executed today. These are akin to trade usages. Hence, you are entitled to.
Trade usage was never a claim, but I must.
Was never argued also.
No, never.
Right, we said it's not argued. But my respectful submission is that today, when law recognizes an exception, and this exception has been recognized not just in this judgment, but subsequently also on Assam State Electricity Board, which is a 3-judge bench, which is the latest in this line of judgments. I ask myself, was the arbitral tribunal unreasonable in going by a precedent of the Honorable Supreme Court?
Okay, chill. Fine.
My lord, if I may straight away come to the relevant discussion in the arbitral award, just to show your lordships that everything has been taken into account and gone into at great length.
Come to the arbitral award, then come to 34 order.
I bought. My lords, the relevant portion of the award is at volume 1, page 288. Page 288, paragraph 28, legal contentions and findings. With regard to clause 2.2 and 8.3 of GCC, no compensation to the contractor. Both the learned counsel for the parties have placed before us a very interesting legal issue with regard to interpretation of clauses 2.2 and 8.3 of GCC before grant of damages to a contractor in the case on hand. Before we touch upon the applicability of the clauses to the case on hand, we deem it proper to quote the relevant clauses in the case on hand. The contract agreement was entered into at Bangalore on 21/12/2009 between the respondent and the claimant. The general terms are set out there. The specific clauses are at 28.5. 28.5 continues at page 290. Clause 2.2, the employer shall grant the contractor right of access to and possession of the site progressively for the completion of works. Such right and possession may not be exclusive to the contractor. The contractor will draw/modify the schedule.
Come to 293.
Yes.
That's the conclusion or the summing up of the issue.
Yes.
The talk.
Yes, Manoj. It is the contention of the learned counsel for the respondent that in terms of clause 2.2 and 8.3, in the event of delay, no compensation is payable. It is also the contention of the learned counsel that clause 8.3 provides a right of liquidated damages for delay. On the other hand, the learned counsel for the claimant would oppose this on various grounds, including the applicability and legality of these clauses.
That's your virus challenge, in a way.
My virus challenge. Both counsels have elaborately argued with regard to the legal interpretation and applicability of these clauses. The learned counsel for the claimant has raised several propositions of law, reading as under: 1, whether clauses 2.2 and 8.3 of the GCC are contrary to section 73 of the Indian Contract Act and hence void in the light of section 23 of the Act. 2, assuming without admitting that clauses 2.2 and 8.3 of the GCC is to be valid, whether these clauses would apply to a judicial fora such as the arbitral tribunal. 3, whether clauses 2.2 and 8.3 of the GCC to be valid, whether the contractor has put on notice the employer in relation to compensation during the extended period of contract and the employer accepted the performance unconditionally. This is the Sarvesh Chopra test. 4, whether these two clauses are applicable only during the extended period of contract or even thereafter. 5, whether these two clauses would apply in the event of a fundamental breach. 6, whether these two clauses would apply in the light of doctrine of active interference. 7, whether despite these clauses, section 54 and 55 of the Act would provide a right of compensation independent of the contract. As against these propositions, the learned counsel for the respondent would strongly argue that this tribunal, being a creature of the contract, is bound by the terms of the contract. He would say that the tribunal is bound by the terms of the contract and it cannot travel beyond the terms of the contract. After hearing, we deem it proper to hold that the learned counsel of the respondent is right in his submission with regard to the jurisdiction of the tribunal in terms of the contract, but it cannot be forgotten that the power to interpret / power to apply its mind to the facts of the case of a claim in a contract is not taken away in arbitral proceedings. To settle law and nobody can dispute the same. The claimant has placed before us various judgments in support of the legal submission. After hearing the parties, we are of the view that we should first take up the issue with regard to the applicability or non-applicability of these two clauses to the case on hand. If the clauses are applicable, then the other legal questions, including legality of the clauses being contrary to Section 73 of the Contract Act or other proposition raised by the learned counsel for the claimant, would not arise. Therefore, we deem it
to 301.
Yes.
28.26. Now read this para, very interesting.
Yes.
Read this.
Therefore, we have interpreted clauses.
No. the
28.26.
second, The next para. Having
Yes.
come to this.
Having come to this conclusion, the next question is as to whether a complicated question of law with regard to clauses binding on the tribunal, exclusion not applicable to the extended period, exclusion period not applicable when there is a fundamental breach, doctrine of active interference, reciprocal promissory estoppels, and sub silentio are not required to be gone into in light of our accepting the notice contention and the applicability of Northern Railway case. That's Sarvesh Chopra. Therefore, we deem it proper not to express any opinion on these contentions urged by the parties. Therefore, in terms of law and in terms of the facts available in this case, the claimant is entitled to claim compensation, and claim of compensation is certainly arbitrable by this.
But we must tell you,
Yes.
the tribunal should have gone into this question. See,
No, no.
it's the binding nature of the contract on the tribunal also. That's right. And this is one of the poser also. You see, having come to this, next question is whether the complicated question of with regard to clauses binding on the tribunal. That's important. Whether they should have said very well. What they say is the tribunal says in view of Sarvesh Chopra, everything we say that this is applicable need not be gone into. That means the clause can be, you can make a claim based on that particular, though there is an exclusion, you will not make it. That's what they say.
But my lords, that finding is in light of the finding from para 28.23. And Royal Lordships can attention to 28.23 at page 299.
No, they have summed up in 28.6.
Well,
They say clause of binding not applicable to the extended period, exclusion period not applicable when there is a fundamental breach, doctrine of active interference, reciprocal promises, estoppels, sub silentio are not required to be gone into in this. And mind it, they say, and accepting the notice contention and the applicability of Northern Railway case. This applicability of Northern Railway case is Sarvesh Chopra.
Yes, Manoj. That is from 28.23.
So what they say, we have accepted applicability of Sarvesh Chopra in this facts. We will not go into that.
Yes, my lords. Because the reason they say this, my lords, is that since they hold that there is an accepted exception to an exclusion clause, we don't have to go into the other issues. And that they hold from 28.23.
That's how, very well. That's how they say Sarvesh Chopra is applicable.
That they say in 28.23. If I may
read it.
Page 299. In the judgments relied upon by the learned counsel for the respondent, that is Big Brothers and Ramnath, the apex court has no doubt earlier ruled that no compensation is payable in the event of a clause of no compensation in terms of the contract. There can be no quarrel over this proposition. But a court of law has to understand the principles laid down in a judgment in the light of the facts placed in that case.
You rely upon Padma Sundar Rao.
I bow down.
Yeah. Okay, go ahead.
We see from the judgment cited by the learned counsel for the respondent that there was no notice as in the present case with regard to compensation in terms of the documents placed before us. However, the learned counsel for the respondent would argue that the court has to read the judgment in the light of documents available in the case on hand. We do not accept this contention. We cannot ignore the admitted facts while applying the legal principles to a case on hand. Nowhere in those judgments there is a reference to any notice whatsoever issued by the contractor in those cases. In the present case, as mentioned earlier, there is a notice issued by the claimant followed by several letters. In the light of noticing the notice, the judgment of Northern Railways is applicable and law laid down therein. However, the learned counsel for the respondent would say that the latest judgment, namely ONGC and other cases, are to be followed. There can be no two opinions on this. In fact, the full bench of the Karnataka High Court has ruled that in the case of judgments of two judges, the latter judgment has to prevail. If those latest judgments are distinguishable on facts, certainly the tribunal has to take into consideration the earlier judgment of the Supreme Court. Therefore, on facts, we are satisfied that in light of the notice in terms of the material available on record, we are of the view that the judgments cited by the learned counsel for the respondent are inapplicable. And on the other hand, the judgment of the Apex Court in Northern Railway case is applicable to the facts of this case. Therefore, respectfully following the law laid down in 2002 for SAC 45, we deem it proper to hold that the claimant is entitled for a claim for compensation despite clauses 2.2 and 8.3 in the light of the claimant putting on notice the respondent with regard to the claim for compensation in the case on hand.
Okay.
At this stage, we also notice the judgment of the Supreme Court in the case of G. Ramachandra Reddy, where the Supreme Court has considered the interpretation of a contract. Supreme Court has ruled in para 19 of the judgment as under. We may at the outset notice the legal principles governing the disputes between the parties. Interpretation of a contract may fall within the realm of the arbitrator. The court, while dealing with an award, would not reappreciate the evidence. An award containing reasons also may not be interfered with unless they are found to be perverse or based on a wrong proposition of law. If two views are possible, it is right that courts will refrain itself from interfering.
Where are the two views here?
My lord, here the first view is the ONGC versus Big Brother's view. The second view is the Sarvesh Chopra view. The Sarvesh Chopra view is a carve-out when there is an exclusion clause. The ONGC versus Big Brother's view is a case where there is a clause, the tribunal has ignored the clause, and because it has been ignored, the court goes ahead, the Honorable Supreme Court goes ahead and sets aside the award.
There's one thing.
Yes.
Is this, can the tribunal say there are two views possible? Let's take a hypothetical example. There are two judgments. One speaks, both are at variance on any issue. It can be said these two views are possible. And then say, picks up one view to say that I am following this view. Can that be said?
No, my lords, but what the Honorable Tribunal has done is it has distinguished the Big Brothers line of judgments by noticing that in those judgments, the notice requirement as recognized in Sarvesh Chopra did not exist factually.
That's a better way to put it. But to say that there are two views are possible, we may not.
That's not my proposition. My respectful submission is that in Big Brothers and all those judgments, that third condition in Sarvesh Chopra, that condition was not met. Therefore, my lords, my respectful submission would be that the default view would be Big Brothers, where the tribunal ignores the clause. But where a factual scenario that falls within the four corners of Sarvesh Chopra exists,
okay,
then Sarvesh Chopra would apply.
Now let's see what the 34. Now tell us one thing. Is this the only claim which is under challenge?
Yes, my lords.
Only claim. That's
Only
right,
claim.
Mr. Ram?
The other claims were challenged, but the tribunal refused to identify this as a separate distinguished issue, and it set aside only to this section. We have complied with the other.
Oh, you have complied with. So
That
this is, we are only concerned with that.
The award of damages contrary to the contract.
That's
The rest of all other claims we have settled.
Yes.
50% granted against you in their favor.
Yes.
Yes.
Now, okay, very well. Now come to 34.
34 finding. 34 finding, my lords, is that para 53 at page 379, volume 2.
Yes.
Para 53, on going through all these decisions relied by either party, many of these decisions are even considered by the learned arbitral tribunal in the award. Arbitral Tribunal has also found that as per clause 2.2 and 8.3 of the GCC, for any delay in handing over the site or any delay on the part of the employer, the contractor will be entitled to only reasonable extension of time and is not entitled for any compensation. The Learned Tribunal has even reproduced relevant portion of clause 2.2 and 8.3 of the GCC, which contain no damage clause. In the present case on facts, by considering various grounds of delay as mentioned in several letters of EOT submitted by the contractor to the employer, Tribunal has held that there is a delay caused by the employer. The Tribunal has also noted that on some aspects, even there are lapses on the part of the contractor which contributed for delay. These findings of the Tribunal is based on the facts and on consideration of the documents and evidence placed before the Arbitral Tribunal. Therefore, in finding as to cause of delay and as to whose fault delay is caused cannot be re-agitated under section 34, as court cannot reappreciate evidence and cannot place its view as against the possible view that has been expressed by the Learned Arbitral Tribunal with regard to the reasons for the delay in completion of the project and the circumstances which led to seek extension of time. Crux of the matter is, when delay is attributable to the employer as held by the tribunal, whether the employer would be liable to pay compensation or delay damages. As mentioned above, clause 2.2 clearly bars payment of any damages or compensation for delay in handing over of the land and even for any other reason. As per clause 8.3, for delay by the employer or the engineer to hand over the contractor, the site necessary for execution of works are in.
Come to pay para 56.
Yes. With your lordship's permission, can I begin from 55? Such clauses in the agreement which bars payment of damages for the delay caused by the employer are upheld in many decisions cited by the Learned Counsel for the plaintiff. The decision of CH Ramalinga Reddy, Ramnath International and ONGC versus Big Brothers, when such similar clauses were present in the contract, Honorable Supreme Court has set aside the award which has awarded compensation for delay. Even the tribunal has noted these decisions and found that as per those decisions, compensation cannot be paid. However, tribunal has by considering the decision in Sarvesh Chopra referred above, has proceeded to award delay damages to the contractor. On looking to the award finding of the tribunal on entitlement of claimant for compensation from employer for delay caused is entirely based in the decision in Sarvesh Chopra. When its senior counsel for the plaintiff has serious objection for relying on the decision for deciding entitlement for compensation. On going through the entire decision, as rightly argued by the Learned Senior Counsel for the plaintiff, decision in Sarvesh Chopra is not on the point as to whether, in spite of having a clause barring payment of compensation or damages for the delay caused by the employer, the contractor is entitled for compensation. This decision is on the point as to whether accepted matter could be referred to arbitration and whether particular dispute is an accepted matter. The Honorable Supreme Court in this decision has held, for the reasons mentioned in the decision, that particular disputes in claims 3, 4 and 5 were accepted matters. The Honorable Supreme Court has upheld the decision of single judge of the Honorable High Court of Delhi, who has held that claims 3 to 6, which were accepted matters, were not liable to be referred to arbitration. Therefore, on looking to the facts of the case before the Honorable Supreme Court and finding of the Supreme Court, point as to whether compensation could be claimed by the contractor in spite of having a clause in the contract, that employer is not liable to pay any damages or compensation to the contractor for the delay caused by the employer was not for consideration before the Honorable Supreme Court. In Sarvesh Chopra decision, Honorable Supreme Court in para 15 has considered section 55 and 56 of the Indian Contract Act, which deal with contract in which time is the essence of the contract, and held that it appears that in Indian law, though the contractor had undertaken not to make any claim for delay in performance of the contract occasioned by an act of the employer, still a claim would be entertainable if the contractor had intimated the employer about such claim and employer accepts performance in spite of such notice by the contractor. This finding of the Honorable Supreme Court do not appear to be the ratio decidendi of the decision in Sarvesh Chopra, as this point as to whether the contractor can claim delay compensation if he has put the employer to notice while seeking extension was not the point involved in the case and is not the basis for the decision in Sarvesh Chopra. On the other hand, subsequent decision of the Honorable Supreme Court in Big Brothers, which is reported in 2010, is directly on the point. In Big Brothers, it is clearly held that in view of clause 5A of the contract barring claim for damages at the time of extension of time, if work is delayed for whatever reasons and including delay attributable to ONGC, that is the employer, contractor will not be entitled for any compensation or damages and will be entitled to extension of time only, and that the finding of the arbitrator awarding compensation in violation of the bar contained in the contract is held to be beyond jurisdiction. The finding of the Honorable Supreme Court and the decision in Wig Brothers is ratio decidendi of the case and would be a binding precedent. Apart from this, even in CH Ramalinga Reddy decision referred above, which is a decision of 3 judges of the Honorable Supreme Court, is also on similar point where the Honorable Supreme Court has held that where the contract plainly barred the appellant from making any claim, it was impermissible to make an award in respect thereof. It is also held that the jurisdiction of the arbitrator is limited by the terms of the contract. Therefore, these decisions relied by the plaintiff would make it very clear that no damages clause for the delay appearing in clause 2.2 and 8.3 are binding clauses of the contract and not a mere statement. As per the decision starting from Continental Construction till Wig Brothers, relied by the plaintiff, when contract specifically bars payment of compensation to the contractor for delay caused by the employer, the contractor is not entitled for compensation, and such clause in the contract cannot be ignored while passing the award, and such award in violation of the terms of the contract as held in Wig Brothers is beyond the jurisdiction of the arbitrator and it requires interference. The decision in Sarvesh Chopra is on different facts and is not on the point involved in the present case. Learned Arbitral Tribunal, without going through the facts of the said decision, has erroneously applied the same to the present case, which is not permissible. As held in Wig Brothers, such finding of the Learned Arbitral Tribunal by ignoring or violating terms of the contract is a jurisdictional error which requires interference. Even I also do not permit such claim for compensation in the decision in Chandalavada Gopalakrishna referred above. It is stated in para 7 that in the decision in Ramachandra Reddy and even in Sarvesh Chopra, it is held that compensation cannot be awarded by the arbitrator if the contract is extended under the terms of the contract. Therefore, decision in Sarvesh Chopra is considered in subsequent decisions by the Honorable Supreme Court, including in Nicholas Piramal India Private Limited, do not support such claim for compensation. Even in Sarvesh Chopra decision, which is basis for the finding of the arbitrator, the decision in Ramalinga Reddy, and also the decision in State of UP versus Associated Engineers and Continental Constructions are all referred with approval. Therefore, the decision in Sarvesh Chopra will not entitle the contractor to claim compensation in violation of specific terms of the contract, prohibiting such claim for compensation. Apart from this, in the decision in Sarvesh Chopra in para 15.3, it is mentioned that if the contractor makes it clear that escalation of rates or compensation for delay shall be made by the employer and the employer accepts performance by the contractor in spite of delay and in spite of notice, then the contractor is entitled for compensation. Even if this observation is held to be applicable to the present case, same is not properly applied by the arbitral tribunal. On looking to EOT sought by the claimant on 5 times, only in EOT 1, the claimant contractor has stated that he is seeking extension of time and that cost implication would be submitted to the employer later. In application for second EOT dated 24/3/2012, contractor is requested for grant of EOT as per clause 8.4 with price variation clause. In EOT 3, 4 and 5 also, no notice of reserving claim for compensation was given. Employer is not informed that contractor will be seeking EOT subject to payment of damages or compensation in EOT 2 to 5. Even first EOT application stating that the losses are not attributable to the contractor and they are beyond the control, and only after BMRCL fulfill the obligation, they will be seeking final extension along with financial implication, cannot be said to be a clear notice of the contractor seeking escalation of rate or compensation for delay. On reading of EOT request for EOT 1 to 5, none of them are putting specific condition that only if compensation for delay is given, they would proceed with the work, and they are seeking extension of time with the condition that escalation of rate or compensation for delay would be made by the
Facts, on facts also they have distinguished. He has
on
distinguished.
facts, he has gone into it and said that that notice requirement is not met.
That means distinguishing Sarvesh Chopra.
Saying that factually it is not met, but I'll show your lordship how the tribunal has gone into it. Whether at all reappreciation is possible is another issue.
Reappreciation of what?
of the evidence on record.
No, no. See, he's reading a communication from you. See, let's be clear. You are relying on Sarvesh Chopra.
Yes,
He is distinguishing Sarvesh Chopra. That's all.
yes, my lords, but if I may show your lordships the finding of the tribunal on these factual issues. Because today the tribunal has gone to.
Okay, let's put it this way. Did you, while seeking extension of time, had put it to the employer, look here, that I will be seeking damages or escalation, anything of that nature? Did you
Yes,
put it? Have you put it?
Yes, we have.
Where?
I will show you.
If that be so, then this finding would be a perverse finding of the
Yes.
tribunal.
Volume 28. Volume 28,
How many volumes? Which page?
volume 28, page 98, exhibit C 42.
Page 98.
No, where are you reading this?
Sorry, my lords.
This is what?
This is the arbitral records, volume 28.
No, have you filed it here?
Yes, my lord, we filed.
Give us the running page.
This one,
Running page from your paper book.
Page 98, my lords. Of volume 28.
We don't have volumes. We have one concise volume
Survey.
and we have running pages.
Lords, we filed the entire record.
We have
Entire arbitral record we had filed. 31 volumes.
We have last page is 1028. What is the page number?
Mine is. My lords, initially we had filed three, what your lordship is referring to is the 3 volumes that were filed along with the section 37 appeal. Thereafter, your lordship had directed us to file the entire records, which we have filed. The previous occasion.
Have you given the running page numbers in the record?
Each volume has separate page numbers, my lord, from one. As it was before the tribunal. Lord, may I make one submission? I will file a convenience volume with only this.
Just show us that. What does that letter say? Read it. Read that letter.
Yes.
There were five applications for extension of time, not one.
Oh, they have filed 5.
Five. In fact,
For 5 times it got extended.
yes, it was extended for 5 times. And as per Sarvesh Chopra, in each of the application, there should have been a specific request. And your lordships have rightly asked the learned counsel if there was a specific such a statement made. And the answer is yes. Answer is yes. But Lord, if your lordships will ultimately find that there was no such statement, Lord, this will be a case for dismissal with cost.
May I draw your lordship attention to page 98?
Read that letter.
Yes. It's a long letter where we say the LOA was given.
Forget all these things. You have to only say this. While seeking extension, possibly you would have said the delay is attributable to them and you would be claiming damages or escalation, whatever may be. Have you said so?
I may read that out. Once BMRCL and GC fulfill all the obligations according to the contract, we will be seeking the final extension of time as per clause 8.4 and 17.1 of the general conditions of contract, along with financial implications duly notified for completion of the work, and the cost implications to this effect shall be submitted to you shortly.
Very well. Now come to that finding of the 34 court.
Yes.
And that's how it says, the learned judge says, what you have said is not a clear representation.
This is only the first letter.
Uh,
Him read the remaining 4 letters.
What does it say?
My lord,
Or others?
My lord, this is at the stage of seeking the first extension of time. Thereafter, we write one more letter, which your lordship will get at page 57.
What does it say? What do you say there?
Where specifically we say in accordance with, in concurrence with contract clause 8.4 and 17.1, we will be seeking extension of time for the period of 421 days from the original contract closing date, along with financial implication duly notified for completion of the work, and the cost implication will be submitted to you in due course of time.
And how did they give you the extension?
My lord,
How do they give the extension?
in reply to the extension is granted in this.
Where is
at
that?
page 138.
What do they say?
We simply say contract conditions apply.
Sir, I will.
Huh?
We simply say contract conditions apply.
As you say, sir.
Yes.
Which means. that
Thereafter we. This is the excited. The approval. You had requested for extension of time of completion date of whole works by so and so date, vide your office letter under reference number 2. GC vide the letters under reference 3, 4, 5 have recommended for extension of time for completion of works without levying liquidated damages along with revision of key dates. Accordingly, the competent authority of BMRCL has approved the recommendations of GC for extension of time of completion date of whole works on 31/5/2012 without liquidated damages with the following terms and conditions. Without LD from 5/4/2011 to 30/11/2011 with price variation. Without LD from 1/12/2011 to 31/5/2012 with price variation clause frozen as on 30/11/2011. In case of negative price variation, BMRCL shall take advantage. See, revised key dates are as under. They set out the dates. You are advised to complete the above work by 31/5/2012 by engaging additional resources and adhere to the key dates as mentioned in the table above. No further extension will be given by BMRCL. That's all they say.
Come to para 60 of the 34 code.
Yes, ma'am.
Apart from this decision, Sarvesh Chopra in para 15(3) mentioned that if contractor makes it clear that escalation of rates or compensation for the delay shall have to be made by the employer and the employer accept performance of the contract in spite of the delay and in spite of the notice, then the contractor, even if this observation is held to be applicable in the present case, same is not properly applied by the arbiters. EOT sought on 5 times, only EOT claimant contractor as stated is seeking extension of time.
Yes.
Cost implication would be submitted to the employer later.
Yes.
In the application for the second EOT contractor requested grant of EOT as per this with price variation clause. EOT 345 notice for reserving claim for compensation was given. Employer is not informed. The contractor will be seeking EOT subject to payment of damages or compensation in EOT 2 and 5. Even if EOT application stating that the losses are also attributable to the contractor and they are beyond the control and only if this is fulfilled, they will be seeking final extension along with the final. It cannot be said to be a clear notice of the contractor seeking escalation of rate of compensation or delay. On reading of this, none of them are putting specific condition that only if compensation for delay is given, then they would proceed with the work, and they are seeking extension of time with the condition that the escalation of rate of compensation for delay would be made by the employer. That's the finding.
Yes, that's the finding of 34.
Yes.
But my lord, if I may show your lordship the award, because today the issue
we will
is.
continue now. See, continue. We'll have it tomorrow.
Yes.
We'll have it.
Some difficult.
Just we have heard the counsel for the appellant. Just say that.
Lords, some difficulty tomorrow, my lord. They come from outside.
Where are you from?
I'm from Madras, my lords.
You will appear through virtual. You're going back.
I'm going back. Some
Leaving Bangalore and going to.
part heard there, my lords. Would your lordships be kind enough to
Also a part heard. We'll do one thing.
Yes.
Okay, we will, you will not have the botheration of coming back. We'll hear you, then we will hear Mr. Kamath tomorrow. Anything need to be rejoinder, you can give it through virtual.
Lord, I would like to have the pleasure of being there when my learned senior.
We'll hear him through virtual mode.
But something that is part heard there.
With more acoustics.
No, my lord, something that is part heard there. I will be deeply obliged, my lord, if your lordships could.
We will not have it. Let's be very clear. We have heard you this month. We have spent some time.
My lord, some more case law that I need to take your lordships through.
Very well. Okay. So when? Day after.
Day after tomorrow, my lord, your lordship.
Huh?
Day after tomorrow.
Sure? Okay. Day after.
24/1.
We'll have it next week then, Mr. Kamath. Monday.
Tuesday, my lord, subject to your lordship.
Tuesday.
28th.
No, Saturday we can have. It's a working Saturday for us. We'll have it on working Saturday.
Yes,
That would be fine, Mr. Kamath.
yes, please. Saturday will.
Re-notify Saturday.
25/1.
Deeply obliged.
Thank you.
I'm great.
Grateful, my lords.
Kind leave, my lord. Serial number 39, my lord. And for the respondent, for two.
Who were mentioning in the morning? Someone was mentioning for an adjournment.
I was-
You were mentioning, there was someone else
Senior
also.
SG Bhagwan was mentioned.
Was mentioning, where is he?
He's not here.
You mentioning 39, huh?
This corrected matter.
Ah.
39.2 and 39.4.
Yeah, this will take time. You appear for whom?
Minutes, I am in serial number 27 minutes.
39, who appears for the other side?
Was here, senior counsel, R.C. Ravi was appearing. So what happened, my lord? 39.2 and 39.4. Respondent number 2, contesting respondent has passed away.
Lord, I'm Mr. MRC Ravi's junior in this matter. Mr. MRC Ravi is available in the afternoon. He has item
You
number.
appear for whom?
I think appellant.
So what do you want?
No, I've not
What
been
is your
informed.
difficulty?
Difficult, the respondent number 2 has passed away, my lord.
In which matter? He is common respondent in all the appeals.
Two cases, my lord. 39.2 and 39.4.
Huh?
In MFA number 200-283 of 18.
Hmm.
200-285 of 2018. Two cases.
Who is respondent number 2?
So who's initiated the arbitration proceedings against the Nagappa Water?
No, but there is R to dispense with, there is noticed.
Sorry, R1, my lord. R2 is arbitrate.
So this is R1.
Please, Nagappa Water is this.
Who has expired?
R1, Nagappa Water. Contesting response.
Okay. Just say that we have been informed by the council. You appear for R1 otherwise?
Please.
States that R1 in which appeals?
39.2 and 39.4.
39.2 and 39.4 has expired.
Fine, yes.
Intends to move an application bringing the LS on record.
But I think it's a construction company.
Sorry, is it so?
I think a representative character.
Oh, very well. You don't know. You don't know. What do you want to do? Tell us. It stands abated qua him.
Please, I think you pass, I think abates, you file necessary documents to show company has appointed representative to insert up in the place of deceased respondent number 1. 1 week time, you file necessary memo along with the documents.
Just say at his request, has expired, at his request, re-notify.
2 weeks.
Who is R2, R1? Okay. He is the contesting party.
Please.
Very well.
My lord, serial number 15, my lord.
Number 27 minutes. Judgment and decree is in Kannada minutes. I have to welcome.
Which
Translate.
number?
Serial number 27 minutes.
Yes.
The judgment and decree minutes is in Kannada.
You have to, yes, you have to file translation.
Yes, minutes. So,
Let's say that it translates 27, huh? Let the English translation of the Kannada documents be filed. Within 4 weeks, list on. What is 15?
My lord, 15, I am representing first respondent, my lord. This is posted for orders, but the appellant's counsel expressed that she wants to argue on merits. My lord, if it is on, my lord, may I get 1 week time, my lord?
Passed over, my lord.
What do you want?
My lord, need 1 week's time, my lord. I am for the first respondent, my lord.
At the request of counsel for R1. You are the contesting party?
Yes, my lord, I am the contesting respondent. My lord.
No, you are the appellant.
Appellant,
Who
yes.
is for the respondent contesting party?
I am for the respondent, my lord.
You notify. Chalo.
24.
Court officer pass over ಆಗಿದೆಯಾ ಅದು ಆಯ್ತಾ
my lords, with kind indulgence. Lord, how far I am fair in making this submission at this hour without memo. Lord, yesterday, there was a case between me and Mr. P.D. Swarana. And your lordship posted the matter to the 13/2/2025. And in the meanwhile, orally stated not to precipitate the matter so far execution is concerned yesterday. I was not going to pass any orders, not to precipitate any matter. Lord, it was at about 4:15 p.m. and 4:30 p.m. they have taken the warrant and it warrant returned. Now I have filed the memo saying that yesterday the court has asked him not to precipitate the matter, but his colleague says that there is no such thing said in the open court. This is our problem.
So what can we do? If you want any hearing, you file an early hearing. Tell the council we can take up.
No matter, I bring you to notice of how the council, though they are.
Treat as and when the matter will be taken up.
Because yesterday I wanted to show the very live streaming is there. Yesterday it was not live. Live streaming is not there. Otherwise, I could have actually had it. Rather, trial judge says that unless some orders, I cannot act on the memo.
See, you file, no. Either one thing, you want to file a memo, call the council. If you want any listing of the matter or an early hearing, that's how we can do it. But it has to be in the presence of the council. Okay, so.
I have also given him the information that I am actually moving the court at 2:30.
But if you ask the council to come here, what is that?
Right.
If you want a listing of that matter, we can list it also.
Move. I move the memo.
Move the memo. The council will be there. Surely we'll look into it.
Well, what has happened is oral instructions to the council. Sometimes it backfires.
We say nothing. We take the council is an officer of the court.
Yes, mind it.
And we take that way.
When actually I telephone.
The assurance is given is as good as an order of.
Yes. That is.
Next. You just call the council, we'll see.
Sorry. One submission. My lord, serial number 39 has been adjourned. It is with regard to finally one of the respondent is deceased. For that reason, it has been adjourned. I am for the appellant. There is one more matter, my lord, which is next matter. That is 40, serial number 40. That is also a related matter.
It's connected with that.
It is not connected, my lord. It is reaches are safe. So the argument will be same.
We will have it on the same day. Just 40 also re-notify. Same day, ma'am.
You are for appealing in both the cases.
Yes.
Please.
Serial number 23, Rajeshwar.
I appear for the respondent. Lord, I apologize for being unable to be present yesterday because the matter was called. Lord, if I may submit.
Yes.
Lord, sir. There was a memorandum of understanding dated 16/6/2014, wherein the respondent herein, who was the claimant before the arbitrator, had the facilities to be used, was required to use the facilities in the hospital and run the hospital. He was required to maintain the hospital. My humble submission is, Milords, there were breaches, Milords, where the high value equipments were removed. Milords, a lot of aspects, Milords, which clearly show that there is a breach on the part of the respondent. The claimant, Milords, in fact, was required to pay the security deposit for which he had given checks. So my humble submission is, Milords, the situation where the contract is abruptly terminated in clear violation of the contract. Now, the question that arose for consideration before under section 34, if I may submit, the award gives a compensation of 14 lakhs to the claimant and rupees 42 lakhs to the respondent by way of counterclaim. I had challenged, that is, the claimant had challenged it under section 34 with regard to the counterclaim. No challenge was made by the respondent. The honorable trial court, the honorable court under section 34, set aside the counterclaim granted to the respondent on the ground that the termination was illegal, was in violation of the memorandum of understanding, and it is not open for the respondent to take benefit of his own wrong. And such being the case, that's it goes to the root of the issue being patently illegal. In the sense, it wouldn't be open for the respondent to take benefit of his own illegal act of terminating the contract, giving a day's notice vis-a-vis 30 days notice, which was contemplated under the MOU. So that I must submit is under challenge under section 37 before your lordship by the appellant herein, who was a respondent before the arbitrator.
See, what he's saying is, he's only claiming whatever he has incurred. That's all. It cannot be by way of a damages.
But if I may submit, the claimant also has incurred huge expenses. In fact, my claim is around.
You are right, but you did not challenge it. Did not challenge it.
We have challenged it.
Where?
Before under section 34.
Then what happened in 34?
34, their counterclaim was disallowed.
And
My claim was upheld
to the extent?
to the extent of 14 lakhs,
That's all. What was your claim for?
7 crores.
That has not been given. No challenge. What has been given is 14 lakhs or odd, what you are saying. That's all. And now 34 court set aside their claim or counterclaim, whatever you may call it. And insofar as 14 lakhs is concerned, is upheld. So now he has come against that to the extent where what he has been denied. That's all.
So if I may. Yes,
And you are not challenging these 14 lakhs.
No,
if I may. No, that's my humble submission is that's the section 34, that's the judgment made. That is an order in view of the fact that there is a breach of the contract.
We will see that.
Yes, ma'am.
That we will examine it. What has been granted, what has been rejected against him by the 34 court, that's all we are examining. And he is not challenging whatever you got it. He is not challenging that. 14 lakhs, very well. Maybe, are you saying that subject to set off?
it will be set off.
That's what maybe he will argue, because ultimately he has to pay you 14 lakhs. And he has got 42 lakhs, that need to be looked into, that's all. And what he's claiming is this 42 lakhs, now see the arbitrator, what does he do? Where is the arbitrator about?
That's
Page 58.
page 58. Property portion, page 81.
Now, what he says is the page 54, para 44.
The order, section 34.
This is 34. Where is that arbitration about?
That's page 58 onwards, my lords.
58.
My lords will see that portion is at page 79, para 63.
Regarding 25 lakhs, where is your claim referred to here?
Last 3 lines, my lords. Respondent is entitled to this 42 lakhs 40,000 44 towards rent from 16,6 to 12,9
As
and electricity
electricity.
charges.
So he said what has been granted is what is the amount which he has paid to the landlord. That's all. And is it your case that no such amount was paid?
No, there was no such amount liable to be paid. In view of the
Very well. We'll test that. We'll test that. Okay, now come to where does the arbitrator deals with that there is a liability for them to discharge to the extent of 42 lakhs under the agreement.
Plus class 6.1, that's all is referred to, my lords. My lords will come to page 73, my lords.
Who is HHPL?
Respondent, my lords.
claimant.
Claimant before the arbitrator.
You.
Yes.
HHPL shall maintain and keep valid account existing approvals along with the necessary. You are reading 3.1 or 6.1?
6.1.
Where is 6.1?
Lords, may I take the clause as 48, my lords? Para 48. Page 73, running page 73. The
Mhm.
second part of clause 6.1, para 48. Internal
Para
page 18.
48 is, you say page 73, page.
Lords, 73
Second
is
part of the clause is 6.1 imposes an obligation on the HCG
to make payment to
is to
HHPL.
make payment to HPHPL.
Please,
You are HCG,
I'm HCG. my lords.
he is HPL. So
Please.
you have an obligation. Regarding this aspect, it is to be noted that HHPL had made certain payments on behalf of HCG, then it could claim the money back. The HHPL had not raised any bill or had paid any amount to other parties on behalf of HCG to have the benefit of subrogation. If HHPL has done so, the SHCC has failed to make payment, then the question of respondent causing a breach would have arisen. As such, I am of the conservative view that the respondent has not committed. Now, the clause 6.2, where is the clause in support of your claims that you are entitled to whatever money you pay to the third parties?
Plus, may I take my lords to the memorandum of understanding, my lords? At page 98, clause 6.1. It's agreed and
Understood
understood.
between the party that just read it.
All the patients are to be billed exclusively by HHPL in the name of HCG hospitals. HCG shall ensure that the gross revenue earned by HHPL from the hospital shall be credited to a designated bank account opened in any of the scheduled commercial banks acceptable to the parties, and shall be operated jointly by the signatories of HCG and HHPL. HCG shall be entitled to deduct expenses incurred by it due to the operation and management of the hospital by HHPL, which shall include but not limited to rent, taxes, duties, insurance, repayment, and loan taken by HCG in respect of equipment, together with interest payable thereon. Payment towards AMC and CMC of the equipments as and when due and payable, and other expenses related to the functioning of the hospital (brackets expenses). HCG, after deducting the said expenses, shall pay the balance amount to HHPL by way of check or account transfer, subject to HHPL raising bill to HCG on monthly basis. In the case of any shortfall in the account towards the expenses, such shortfall shall be paid by the HHPL to HCG within 10 of subsequent month.
Now, where did you tell him this? This is what I have paid to the third parties, and I am adjusting this amount.
Plus in the termination notice, madam.
Show us.
That's page 108, madam. This is to inform you that we are hereby terminating the agreement for non-payment of the security deposit and for breach of the terms and conditions of the agreement with immediate effect in accordance with clause 12(2)(a) of the agreement, after considering that the breaches committed by you are incapable of being rectified by you. Accordingly, agreement stands terminated with effect from 11 September 2020 upon service of this notice. Further, as you are aware, as per the terms of the agreement, you owe us an outstanding amount of approximately rupees 51,79,000. The breakup of the same is enclosed to this letter. Towards the recovery of the said outstanding amount, we are presenting the checks bearing number so and so. A breakup, my lords, will get at page 109.
What is the response?
They terminated in a day, it's severe violation. But the other submission is they were taken by surprise, the doctors, the patients, the staff were all thrown out.
You're
That day is
right.
not-
But where is your reply? See, so now he made a counterclaim to that. You must have filed a reply to the counterclaim, objections before the arbitrator. We'll only see the finding of fact.
Your Lordship would kindly appreciate that a month's notice is required. If I may just draw your Lordship's attention, that within a span of 3 months, the agreement was terminated.
Wait. You must have pleaded before the arbitrator.
Yes.
Where have you pleaded? Let's see what is the finding.
But if I may just draw your Lordship's attention to the next paragraph of the agreement.
Read it.
6.2.
Yes,
Upon the expiry of 12 months, the period, which is contemplated in the agreement. By virtue of clause 2.1, both the parties, draw your attention to point 2.1.
no, you said 6.2, no?
Clause 6.2 is, yes, I draw you. 6.2, upon the expiry of 12 months from the date of the agreement, HHPL agrees that HCG shall be entitled to retain 8 lakhs per month or a percentage of the gross revenue before deducting the expenses covered in clause 6.1, and the balance shall be paid to HHPL whichever is higher. And then the parties agree that the aforesaid percentage shall be mutually agreed upon, and at the end of 6 months from the date of this agreement. In case the hospital achieves positive EBITDA, that is earnings before interest, tax, depreciation and amortization, before 12 months from the date of the agreement, HCG shall be entitled to retain 8 lakhs per month or such percentage of the gross revenue as agreed upon before deducting the expenses for these months where the hospital operations achieve positive EBITDA. At the end of 12 months, cumulative position can be reviewed to arrive at actual amount to be retained. If I may submit, Lords, in a span of 3 months, it is terminated. That's, if I may just draw your Lordship's attention to 2.1 minutes, clause 2.1 of the agreement. Page 93, running page number 93.
Where have you set up this case before the arbitrator?
Lords, our case is that, Lords, the whole arbitration has arisen because of illegal termination in violation of this.
Right, you will set up, na? He has filed a counterclaim. Where did you defend your counterclaim, his counterclaim?
We have defended
Saying what? Let's see what is the finding.
of the arbitrator.
That's right.
If I may just draw your Lordship's attention to 2.1 before I.
See, arbitrator gives it, 34 set asides it.
Yes.
That's it.
To the same.
We are testing that. That's all.
2.1, if I may.
Read it.
Both the parties have mutually agreed to enter into this agreement for a period of 1 year, whereby HHPL shall render medical services to the hospital, which would commence from June 16, 2014. HCG shall have the liberty to renew this agreement for such further period upon mutually agreed terms and conditions within 1 calendar month. My humble submission is this 12 months becomes sacrosanct. For me to establish the hospital and to ensure that the expenses that I incur is even break even, it would require a year's time.
Very right.
Plus the requirement for the termination is at clause 12, if I may draw your Lordship's attention to clause number 12, termination clause. If I may draw your Lordship's attention. In 12.1, unless terminated earlier in writing pursuant to the terms hereof, this agreement shall continue to be in force during the initial term.
What is the initial term?
12 months.
Unless terminated earlier in
Yes.
writing.
Plus clause 12.2A would become relevant. If I may draw your Lordship's attention to 12.2. Without prejudice to the other rights or remedies which it may have, either party shall be entitled to terminate this agreement forthwith by notice in writing if the other party shall have committed a breach of this agreement, and either such breach is incapable of remedy or shall have continued unremedied for 30 days after a notice specifying the breach and requiring the same to be remedied has been given to the defaulting party. Plus, it is for them to have arrived at a conclusion that this is irremediable. Plus, the default that they say is I've not paid a deposit of 25 lakhs while I've given a check to them. Says I've not paid some rents. Plus, these are remediable situations. Notice is not given. The termination is not in accordance with 12. If I may draw your Lordship's attention to the award, the relevant portion.
What is the finding on termination of the learned arbitrator?
Yes, Lord, if I may draw your Lordship's attention.
Para 52, internal page 19 of the award.
If I may just draw your Lordship's attention to internal page 20, para 55 of the award.
Which page?
Internal page 20 minutes of the award.
Internal page?
Internal page 20 minutes.
Yes.
Running page 77. 55, if I may draw your Lordship's attention to para 55. Keeping these principles
whether the parties are entitled to damages as contemplated is an important aspect. Before considering this aspect, whether the termination of MOU is proper needs to be considered. 56. Clause 12 of the MOU contemplates two types of termination. That is by giving 30 days notice where the non-compliance is of a curable nature and forthwith where the breach cannot be cured. 57. Breach of law and commission of criminal acts could be stated as that of non-curable nature, while the other breaches could be broadly categorized as curable breach, as in the MOU. It is not specifically classified as to what could commutate to a curable breach and a non-curable breach. In the case on hand, the breaches as committed by the claimant falls broadly in the category of a curable breach. They do not fall in the exceptional nature. The respondent, therefore, has taken a wrong step by adopting drastic action. On account of the abrupt closure, the claimant would be exposed to hardship of answering his client, workmen, and other people who had lent support to the claimant till then. If 30 days time had been given, probably then the claimant would have even withdrawn himself and would have minimized the loss. The stock of claimant, which was there at the hospital, could have been taken away and used at some other place. The same was not possible on account of abrupt closure.
So what is his submission? What is his conclusion?
Plus, the termination is not in accordance with the MOU. It's a clear breach.
Where does he hold?
Yes, sir. May I request my lords to read para 52 before my lords?
Where does he hold? His termination is not correct. He should have declared it.
But the analysis, not my humble submission.
Very well. Now let us put it this way. So the termination is bad. That's what the conclusion is according to you.
Termination is unfair.
Will he still be not entitled to the money which he has paid to the third parties?
He's not entitled.
Why?
Because it's on account of his breach, Milord, I have suffered. Milord, it's in clear violation of the contract.
No, just we will rephrase it. Let's assume the contract is in vogue. He has not terminated. Okay? He has paid certain money to third parties, which you are liable to refund or restitute to him. You are under an obligation.
Plus,
Just listen. You are under an obligation, yes or no?
only so far as MOU, Milord, the electricity charges, the rental.
The rent charges.
Yes.
That's right. So what are the heads under which this 42 lakhs has been given?
Milord,
Under those heads?
under the heads of electricity and rent.
That's all.
Yes.
How termination or a wrong termination will have a bearing on the claim which he has got.
But my humble submission is on account of the wrong termination, Milord, I have suffered huge loss and it is in clear violation of the contract. In view of the fact that there is a wrongful termination, Milord, he cannot take benefit of his own wrong. Milord. Now, Milord, the position
Now, is it, just tell us 1 minute, sorry. Is this claim of yours is post termination?
No, my lords, for the period prior to termination.
But my humble submission is, he would not be entitled for anything in view of the fact that I have suffered huge damages. Not if I may just submit, the hospital was closed, the doctors were asked to get out, the staff were thrown out, plus, and everything in the hospital was.
Yeah, yes, you are right. That is post termination. But something which has happened prior to termination, is there no obligation?
Not my humble submission is.
No, you have to answer this. See, what has been
My
given
humble
is,
submission, I get, Milord, I get. Not my humble submission is, if the termination was in accordance with the contract, Milord, he would have been entitled to all the claims, Milord.
he is not pitching his case that far. He is only saying whatever I am entitled to before termination, give me.
Milord, my humble submission is, he wouldn't be entitled in view of the wrongful termination.
How wrongful termination will have a bearing on pre-termination charges? You tell us. How? And it is not his claim for post-termination. Point. That's what we are asking you. Is there any say that even if a termination is wrongful, he is not entitled to any benefits under the MOU? Say that stipulation. Show us that stipulation. And mind it, you made a claim for 7 crores.
Yes.
That is all the losses which you have suffered post termination. That has not been given by the arbitrators.
Not post termination.
Whatever, very well, including post termination.
Not both in prior and post.
So what has been given is 14 lakhs. Maybe for certain reasons he has given, neither he has challenged, neither you have taken in, challenged it under 34, saying that you are entitled to 7 crore. That is also not. We are only today on that 42 lakhs. We are asking you, according to him, unless you prove it otherwise, that these 42 lakhs are post termination, then your argument that for his own breaches, he has been given the claim, awarded the claims which otherwise was not entitled. You show us that for his own breaches, but that would be post termination. His case is, this is pre. Pre, in any case, I am entitled to in terms of 6.1.
Lords, if I may submit, Lords. Here is a situation, Lords, where the pre and post termination, Lords, cannot be looked at in a scenario as is sought to be looked at by the.
Show us under which provision of law, even under the Contract Act, why it could not be looked into. Simple. He is just, putting the claims or the counterclaim pre-termination and post. He said, this I am entitled to be, because he is entitled. Is he not entitled for a claim as a counterclaim for this 42 lakhs in the arbitration? He say, you have claiming 7 crores. I am also equally entitled to 42 lakhs because this is what I have paid the third parties. Unless your case is, there is no evidence which has been placed by him to show that he has actually paid the third parties. Unless your claim is that. Your defense is that. That's not your case.
That is not.
Look in a perspective. Just have all the facts before you and then analyze those. If you are right, if this claim was post termination, then we would go into this clause also whether this termination was justified or not. Though the learned arbitrator doesn't give such a declaration, you are right. Reading between the lines, he says the termination was not correct. He says so. Reading between the lines. Then we would have gone into that, saying that this conclusion is justified. If justified, then we could have put it to him, why, how are you entitled? It's like this. And you may be right. And he should have given you enough opportunity for you to make profits. It's only after 2 years or 12 months was the duration, you terminate by 3 months. How will you earn? Right. So this is where we are. What is your take on that?
So my humble submission is not, the contract has to be seen as a whole, not whether pre or post. Not the situation is not, I have suffered immensely because of the sudden termination. The position is not my invoices, my records, everything was stuck in the hospital. In fact, the arbitrator makes an observation. Only 14 lakhs is granted because no documents are forthcoming.
You should have challenged that denial of 7 crores in 34. You should have actually
34. We have challenged the setting aside of the entire award.
Said no. Did you challenge 34? That denial of 7 crores?
Entire, yes, Mulats. We have.
So why didn't you file it? Your 34 has been rejected. That means 7 crores has been upheld. Denial of 7 crores by the arbitrator has been upheld.
In view of the fact that there is a finding that it is an appreciation of fact, Mulats.
That you should leave. You should have at least challenged it in 37.
Yes.
And there are consequences. The consequences would be this. Then we are proceeding on the premise is this. Your claim for 7 crores for also the post-termination period, has been rejected, which has attained finality. Okay. If it has attained finality, a termination is bad or not bad, you have not been compensated by the damages by the learned arbitrator or by the 34 court. By the learned arbitrator, in fact, which has been in a way upheld in the 34 court. What has been really now in your benefit, to your benefit is that 14 lakhs which he has given. That's all. Now he is saying, look here, very well, all these are pre-termination I am entitled to, which has been granted by the arbitrator. The 34 court could not have given, these are not akin to damages, where the damages need to be proved. These are actually those paid to the third parties which he is claiming. And there is an obligation on your part. It is not a case where under the MOU there is no obligation that you will not pay him. You will pay him. That's what.
Not, my humble submission is given under section 20 of the specifically fact. Let's
Think over it.
may kindly be posted day after.
This day after, we have already counsel for the parties, listen, we'll have it on Saturday. Yes, Saturday.
25.
Next.
Serial number 20, 24.
For the appellant. Suit for specific performance filed by the appellant.
Yes, seeking specific performance.
Please.
Issue notice.
Twenty-five, three. Serial number 25.
I appear for the appellant in this matter. And
Okay,
plaintiff suit for specific performance may not have been dismissed. But court holds
Yes.
Twenty-seven, three. Serial number 26. Shri Shankar
Yes,
Narayan Bhatt.
I will respond.
Appellant.
Issue notice.
It is.
You appear for the response.
Respondent.
Issue notice.
It is barred by.
Huh?
Suit is barred by.
Just see, just show us.
The,
Kindly see the order.
Where is that finding?
Milord, here, the original claim is made for,
We are in first issue notice.
no, notice has been issued, Milord. He is the contesting party, has been served and he is representing.
We will formally issue notice.
Permitted.
Notice has been issued, Milord, already.
Order
Issued.
Yeah.
High court records have come in? No.
Yes.
Yes, sir.
Yes, what do you say then?
In page number 24 of the order,
Okay.
suit is entirely barred by time. In the finding.
No, let's see
Milord.
the pending.
Your lordship kindly see page
Me-
36.
Before that, Milord,
Para 36
Para 36.
of the order, page number 24.
Read it.
The plaintiffs who are claiming maintenance charges have not furnished details of their claim breakup figure. They have not furnished any details whether they are collecting maintenance charges from the other occupants of the apartment. They have not furnished the details regarding the nature of maintenance they have undertaken, whether they have made periodic demands with the occupants of the apartment to pay the maintenance charges. The plaintiffs have claimed rupees 3,71,500 towards maintenance charges without any supporting document. They have not furnished any document to show that the defendant had agreed to pay interest at 18% per annum on the arrears of maintenance charges. The claim made by the plaintiff regarding maintenance charges is very vague and not supported by any document. In these circumstances, the plaintiffs have failed to prove the liability of the defendant to pay the maintenance charges. From the above discussion, it appears that the plaintiffs are not entitled to claim the interest on security deposit, maintenance charges, except rupees 5 lakhs. The entitlement of the plaintiff to recover 5 lakhs from the defendant subject to finding of the question of limitation. The suit is barred by time. On that ground, the suit is.
What are the facts on limitation?
Limitation starts from.
The para 41. File suit accrued on them on 11/6/13 on date DGA has entered into plaintiff orders. The date on which supplementary agreement was, date on which declaratory affidavit was executed by the defendant, the date on which the possession of the two flats was handed over to them. And the date on which the legal notice was. Issuance of notice is running of time to file the suit for it. Has received by letter from the plaintiff check on fatigue and agreed to return the amount before taking the delivery of a share of. Defendant has not disclosed the date on which he took the possession of the apartment. Plaintiff confirmed the possession of the apartment was delivered on the day only the defendant has executed so many account assessments were made in the name of the defendant in respect of a share of the property. Plaintiff ought to have filed a suit for recovery of payment within 3 years from 70 moment before time. In this case, there no case of actual balance period was available to the plaintiff. And the plaintiff has filed an application pre-mediation of the expiry of the days of field. So that suo motu Supreme Court judgment was also considered.
And then
The DLSA.
Corona period, I think, like that.
After expiry of grace period of 3 months provided by. The DLSA had issued a non-starter on. Claim was received by the plaintiff on the plaintiff filed a suit on. When that 3 period, February 2022.
Yes, yes. No.
The time the.
No,
Supreme Court-
Millard, on that issue, on limitation question, I do concede, Millard. I am not, here I am restricting my claim for 3 years maintained prior to the date of filing. That's all, Millard.
Can you do that? 3 years prior to the filing, date of filing.
Yes, Millard.
How much?
Because
is that?
that is 1,19,000 and all.
But tell us one thing, what you tell me is your cause of action to file a suit.
This regarding this Millard claim of, there are 2 claims are clubbed together in the claim. One is about the non-refund payment of refund of 5 lakh. That is time barred. I do consider I am not pressing that issue. So far as the maintenance is concerned, they claimed from the 2017. The date of handing over the possession. She has not paid any maintenance charges till this day.
That is also barred by time.
Well, earlier, it's a recurring cost of action, Millard.
As of today also.
Yes, Millard, even to now also she is not paying. Like this suit is for that.
But where are the averments for that? Where are the averments? You are right. When you file the suit, you filed the suit in April 2023.
Yes, Millard.
Preceding 3 years preceding the filing of the suit. That's right. How much is the amount?
Preceding 3 years is 1,19,000.
This is the claim.
Millard,
It's not a jurisdiction in the sense or a.
no, it is no.
13 of that, paid before the commercial court.
1 minute, let's understand.
Millard, I do consider that statement as you or lordship asked is not there in the pleadings. But they have claimed the entire maintenance prior to the date of filing. But however, in this appeal, I have restricted my claim for the 3 years only. Prior to that period, I am not, but it is not their case that they have paid the maintenance.
Should have alternatively claimed also, in the suit.
Alternatively, they should have claimed, Millard, but
Everything in the realm of, conjectures.
no, not like that, Millard, not in that fashion,
What
Millard.
was the claim for? 17 lakhs
Yeah, 17 lakhs.
initially?
Including interest, etc. They have given the figure. I'm giving up all that. I am not claiming up that 5 lakhs is security deposit, non-refund of and interest on that. No, even in the non-payment of maintenance also.
Tell us 17 lakhs or 5 lakhs, he says alternatively. The file code. 17 lakhs was bought by time.
Millard, the security claiming security refund is barred by time. I do consider I am not pressing it. That 5 lakhs plus interest. No, I am giving it up. And so far as maintenance is concerned, Millard, monthly maintenance payable, it was claimed from the date of handing over the possession. That is from 2017 till the date of filing. Here in this appeal.
It is also barred.
No, that is barred to a particular period, not in entirety, Millard.
Should have said so.
Like even without, Millard, even without seeing under the Limitation Act, Millard, under the Limitation Act, if it is.
What do you say on his point?
Actually, they have not claimed that.
1 minute. Where is your averment in the plaint This seven, whatever, what was the claim? How much was the suit for?
Suit in all, it is about 17 lakhs.
Where is the month?
In-
Where you have said this 17 lakhs is payable from that date to this date? Where do you say so?
Not in the claim.
Yeah, it is not in that question, my lord, what I wanted to.
You don't give a date. That till the date of filing of the suit, your claim is for 17 lakhs. Then possibly you could have argued at least for the preceding 3 years, from the date of filing of the suit, you are entitled to X amount.
Thank you.
Tell us one thing, are you paying maintenance to him?
No,
Why?
no, because they have not given the possession of the property.
You don't have the position.
No, it is admitted, question is admitted in the petition, in the written statement itself, my lord. It is not, for
Where are
first,
you living now?
Two properties, out of one they have handover, another one is still pending.
Against one, you are giving maintenance. Against one, you are giving maintenance.
Regularly that maintenance has been paid. After the filing, that is the.
Where is your claim which says the 17 lakhs is till this date, April 2013, the breakup of this is this? Then possibly we can say, yes.
your lordship,
Claim is out.
my lord, so far as maintenance, areas of maintenance, what was claimed is, regarding other 17, I am giving up. So far as maintenance, 3,71,500 being the areas of maintenance amount payable to the plaintiff along with the interest at 18% from 28/7/2017. 18, page number 18, ink page 18, in my law, learned judge is referring to that. Paragraph number 7.
This order was passed under 711. No. The issues were framed. Where is the finding on this?
Whether the plaintiff proved that the defendant is liable to pay a sum of rupees 17 lakhs 47,367 with interest at the rate of 18% per annum on the order.
What is the amount due is stated by learned judges have called out in para number 7. The total amount due by the defendant is to the tune of 17 lakhs 47,357 as shown here in below. Rupees 5 lakh being the refundable security deposit, so and so, that amounting to 10 lakhs and odd. And B, 3,71,500 being the areas of maintenance amount payable to the plaintiffs along with the interest at 18% per annum from 28/7/17 to 28/3/2023. Amounting to so much is this. In this, my lord, I mean, this particular period, it's barred by time, I do concede. For at least the 3 years prior to the date of filing, that is 28/3/23 to 3 years prior to that, he is liable to pay. Some amount may be barred by time, but not in, it is a recurring amount, his monthly he is liable to pay. It is not as once paying and then it's closed. No, it is.
But it's not true.
And even in the evidence also, defendant has admitted that she is not paying the amount.
Come to pay para 36.
Yeah, para, your lordship may kindly pay para 35, your lordship may kindly. Yes, the DW1, that is a respond hearing, in her cross-examination deposed that she has not paid maintenance charges as plaintiffs have not informed her. She deposed that plaintiffs had asked her not to pay the maintenance charges. She admitted that as per exit P2, she has agreed to pay maintenance charges. She denied that she is liable to pay maintenance charges up to date. This is the plaintiffs who are claiming maintenance charges have not furnished details of the claim breakup figures. They have not furnished
any details whether they are collecting maintenance charges from the other occupants of the apartment. They have not furnished the details regarding the nature of the maintenance they have undertaken, whether they are made to periodic demands with the occupants of the apartment to pay maintenance charges. The plaintiffs have claimed 3,71,500 towards maintenance charges without any supporting documents. They have not furnished any documents to show that the defense had agreed to pay interest at 18% per annum on the arrears of maintenance charges. The claim made by the plaintiff regarding maintenance charges is very vague and not supported by the documents. In these circumstances, the plaintiffs have failed to prove the liability of the defendant to pay maintenance charges. From the above discussion, it appears that plaintiffs are not entitled to claim interest on security deposit maintenance charges except 5 lakhs entitlement so and so.
Now, how much is your figure for preceding 3 years of the?
1,99,000.
That's all.
Yes, ma'am. 1,99,300.
See, this is your DW1 gives the statement in her deposition.
Finding given by the commercial court that maybe.
Have you said so? You will pay the maintenance charges?
No.
Para 35, read it. Read it.
EWM cross-examination had deposited that she has not paid the maintenance charges and the plaintiff have not informed her. She deposited that the plaintiff had asked her not to pay the maintenance charges. She has admitted that as per exhibit P2, she has agreed to pay maintenance charges. She denied that she is liable to pay the maintenance charges. She denied.
What is this? On one hand, she says she is paid and otherwise denied.
But, during
Please.
examination. During her examination, she has denied that she is not liable to.
But
pay
you
the-
will only see the denial, but you will not see the admission.
No.
Read it, the first line before that, just the line before that, she has admitted that as per exhibit P2, she has agreed to pay maintenance charges.
Admitted that
Then-
she has agreed to pay maintenance, she denied that she is liable to pay that maintenance charges.
How would you reconcile? On one hand, you are admitting, another day denying it.
But her deposition.
And you are living in the same flat or whatever is the society?
Same flat, Miller.
Same flat?
For 2 flats, she is in
Already
occupation.
purchased. Property has, flat has been purchased.
So you are living in that flat?
Yeah, he-
They are maintaining it?
Not maintain, he not maintain the flat. Yeah,
Who is
independent-
maintaining it?
independent- Our, my party has taken the.
Then why do you say so? Why do you say so?
Earlier, he has made a story of this maintenance charges and demand that amount.
And how much is payable?
1,99,980 million for 3 years.
Totally false. They have created that, this one documents and they have taken.
Where are the?
Yeah,
Millard,
Invoices.
Millard, the documents produced there, we have claimed, you have issued notice stating that per month 5,500 rupees are payable for 2 flats. Notice has been issued to them, and all the documents are produced. The documents are marked as exhibits, Millard. Exhibit P1, P12, P14 are the documents produced and marked. In that we have stated specifically. Millard, copy, a legal notice dated 29/1/2022, copy of the postal acknowledgement.
Show us the bills you filed April 23, you filed your suit. That's right. You filed it in April 23.
Yes, Millard. Yes.
3 years preceding that date, from April 2020, where are the invoices? From April 2020 to April 23, where are the invoices? Show us.
No, the practice not raising invoices as such. They used to give notice and demand the payment.
Where are the notices?
That is my notice, Millard. Exit P6, the legal notice.
What is the date? What is this legal
That is
notice?
29/1/2022.
For every month, you will not give legal notice.
No, not Millard, because if, the practice, Millard, is a small apartments, about 24 people, apartments are there. There actually the association is yet to be formed, and he was the developer, and he is.
We are asking only this.
Yeah.
Where are your bills, monthly maintenance bills which you have raised on him or them? Show us that.
will not, specifically, the monthly maintenance bills are not stated like that but because of small, because to maintain office, etc., they are not in that machinery. Therefore, they used to demand and they used to remit all the apartment owners except the respondent and another one are remitting it to the bank accounts. And I produced that bank accounts also extract wherein they have been depositing the monthly maintenance charges. That was also produced before the court. And apart from that, I have here also in the appeal also I produced as additional evidence that document which details show about it, the payment of maintenance. And this respondent alone is from the very beginning not paying the maintenance.
What is the breakup of 1,99,000?
That 5,550 million into 36, that is prior to 3 years, 36 months prior to the date of filing million.
Date shows the breakup. Shows the breakup.
Yeah.
Which is the
Yes,
the date? Starting from which date?
Starting from 28/3/2023, 5,550.
From which date?
28/3/2023 to 20. That is this, to be more specific, suit was filed on 11/4/2023, 3 years prior to 11/4/2020. 11/4,
They paid maintenance for 1 month at least.
not even 1 month, my lord.
To take instructions. How much? 199.
No, borrowed by time, that is their maintenance charges.
He filed the suit in 2023 April. That's right. Purely the 3 years preceding the filing of the suit would be within limitation. That's right. Pay for that period.
That's all what I am claiming.
Can't be that I will take the maintenance, everything, I will not pay.
They have produced it in document to show that they are not paid that maintenance charges before they file for.
He says he has filed the document to show that others are paying.
No, such documents.
Bank statements were filed, my lord, and here also I produced as additional evidence, the bank statement extract one.
Very good. So you will take instructions. Take instructions,
Yes, I will.
okay, and come back. Not like this. Just say that we have heard. When do you want?
And they.
And yes, at the request of, we have heard the counsel for the parties to enable the counsel for the respondents take instructions. Re-notify after 10 days. Any genuine claim that need to be adhered to, that should be accepted gracefully.
Five two.
And he has filed a bank statement and everyone was paying.
Yes, ma'am. Except to two, respondent and one more person is not paying. 2 persons are not, others are paying.
I will take instructions.
5-2.
5-2, sir.
Right.
Next month.
27 urgent, 28.
Mandatory now.
Which number?
28, sir.
28.
You file your submissions.
Yes,
Have you filed
I have not filed my
the submission? We thought that it requires.
tail court records may be called for. Tail court records may be called for.
Let the submissions be filed by the counsel for the parties within 4 weeks. The TCR be dispositioned before the next date of it.
The interim order may be extended.
Same order if we need to continue.
The stay petition is coming up for hearing, my lord.
Pardon?
The stay petition is coming up for hearing, my lords.
Which petition?
Stay. They are seeking stay pending appeal. My lord, at the time when the condemnation of delay IA had come up before this honorable court, my lord, at the insistence and at that same time, my execution petition had come up, my lord. Then this honorable court.
Is an interim order already.
Yes, my lord. This honorable court directed that pending adjudication of the condonation of delay only, not to precipitate the matter. Now that delay has been condoned.
It is not.
No, my lord, pending appeal, they are seeking stay, my lord. Usually your lordships are passing a conditional order.
No, how much is the liability?
About 2 crores 79 lakhs.
How much you will deposit? The money degree.
About 25%.
What is the status of this organization? Is it a
Milan is a central government organization. It's a central government organization.
power research?
Central.
Deposit. Deposit deposit.
25%.
25%. And tell us one thing, what is the difficulty? Interest has been granted to you,
Yes, ma'am.
start accruing. It's not, it's a government entity, you
My lord,
don't just
he's-
run away.
My lord, the respondent is a contractor, my lord. This contract is of the year 2009. The monies are due from 2000. My lord, he also has to pay some.
50%, okay? 50% before the registrar general.
50% loan. 50% money, we are a research institute. We don't have generation of money is towards research now.
Who is, from where are you getting the grant in aids? Central government.
Now, my lord, it's all by generation of money through research.
Thing going, there is a money decree in your against you. Let's be clear. The government.
Well, as your lordship rightly said, government industry,
That's more reason you should be more graceful.
20, humble request 25%.
All the issues are answered in favor of the
Well,
plaintiff. my lord.
at least 30% money.
We will only say that. We will say so, but you will deposit. I will make any, see, the money is lying here. If he files an application for withdrawing that amount, we'll put him on terms.
Very well,
Money would be secure. If you ultimately succeed, you'll get it.
very well.
That's all.
With-
It's coming in the court. If he files an application for this thing, we'll put him to terms. So that your money is secure. Okay? Just say that on which date its interim order was passed.
My lord,
28th August.
8th of August.
20 August, my lord. And it's been extended from time to time.
Just say this, counsel for the parties to file return submissions within 3 weeks. The time for recording requisition, 28/2024. The council, this court had noted the submission made on behalf of by the counsel for the respondent that the execution proceedings will not be precipitated. That interim order is being continued.
Yes, ma'am.
To stop by the award. In terms of the award, was it an award or a civil suit?
Suit, my lord.
Judgment.
It's a commercial.
In terms of the
Commercial.
decree. The suit has been an amount of rupees. An amount of
2
rupees.
crores 79 lakhs,
2 crores.
79 lakhs. At page 140, your lordship.
$40.
Page 140, order.
An amount of rupees 279,94,347 has been awarded in favor of the respondent herein. Subject to the appellant depositing an amount of rupees. The proceedings, the execution is still pending.
Is pending, my lord.
50% of the awarded amount. 50% of 279,94,347. In 6 weeks from today with the Registrar General of this court, there shall be a stay of the impugned judgment decree dated 27 January 2024 in Form OS number 5335 of 2015. During the pendency of these proceedings. Full stop. The amount deposited shall be invested in an interest-bearing FDR of a nationalized bank with periodical renewals. Okay, till further orders.
Deeply obliged.
The proceedings, we have stayed the
Execution.
the decree to
Lordship.
the extent of the balance amount. And full stop. Shall we say so? The execution proceeding shall also remain stayed.
Yes, ma'am.
Full stop. In view of the aforesaid order, the execution proceedings initiated by the respondent shall also remain stayed. This the appeal for hearing on.
Deeply obliged.
28/4. Number 29, Shri Siddharth. 29.
The respondent.
Hearing for the plaintiff. Good. Decree is passed. Good. Judgment dated 15/4/2024. Summary decree is passed, my lord.
placed ex parte, my lord, which is challenged before this honorable court, mainly, my lord, on 3 grounds. One, my lord, that strict compliance of order 37 was not.
We filed 913,
Please, my lord, no, my lord,
straight away here.
please, my lord.
What is the ground?
My lord, the first ground, my lord, is pertaining to, my lord, the jurisdiction of the commercial court itself in passing the order under order 37. My lord, the order 37, my lord, kindly take, my lord, it says as follows. The court and classes of suits to which the order is to apply. This order shall apply to the following courts, namely High Court, Civil Court, City Civil Courts, and Court of Small Causes. And clause B, other courts. With respect to that, provided that proviso, provided that in respect of the courts referred to in clause B, the High Court may by notification in the official gazette restrict the operation of this order only to such category of suits as it deemed proper, and may also from time to time, as the case, circumstances of the case may require.
Why should we hear this argument from you? You are ex parte.
Lord,
Exactly.
You did not
My-
appear.
my being ex parte, my lord,
And mind
in
you,
this
we don't
case,
know, we have a possibly on your, possibly you can, your argument is inherent lack of jurisdiction.
inherent lack of
It's
jurisdiction.
a submission, we don't know whether that would gel or not. You can argue that.
Please, my lord. That is the one point that I am seeking, my lord. And the second aspect, my lord, admittedly, the scope of the claim which was placed before the court, because I was placed ex parte, on one date of hearing, I did not appear. My lord,
You did not appear.
leave to defend, I had to take the leave to defend.
Even if you have not filed 9-7, was it an ex parte decree also?
My lord, straight away, there was no evidence, because order 37, my lord, there was no evidence led.
Yes.
So directly, my lord, decree is passed against me. Summary decree is passed against me. So strict compliance of order 37 has not taken place. For this reason, my lord, I have stated that
You did not file leave to defend, nothing of that sort.
no, my lord, in second date, my lord, it was decreed
It was decreed, but you did not appear
on the date which was fixed. My lord, the clerk had taken the order sheet, my
how
lord.
much is the decree for?
Lord, 25 lakhs is the amount, along with 24% per interest per annum is
What
what.
do you say on merits?
On merits, my lord, I have, my instructions are, my lord, there is some due that we have to pay.
How
That is
much?
pertaining to 7 lakh rupees, 7.5 lakh rupees is what.
Your basis for 25 lakhs?
My lords, in the trial court, we have submitted all the original documents, including original ledger account shared by them, original balance confirmation shared by them. Every,
Is the contract?
my lord, contract is
What
basically, my lord, SGR Prime Construction is, they are a builder, my lord, and we are vendors under them. So we provide basically cleaning services or painting services, plumbing service, whatever services they require.
Voices raised?
Invoice are raised, every invoice is duly acknowledged by them. And once they acknowledge, they pay the TDS and they give us the TDS payment certificate for every invoice. And for the entire sets of invoice, we have a balance confirmation from them. We have a ledger account from them matching our claim amount.
Matching.
Yes, that is why we filed an order
At least
37 suit, because order 37
they
says if there is
filed
no
it, but-
trialable issues,
See, let's be very clear.
there is no trialable issue, my
We'll
lord.
test your argument. If it is found incorrect, we'll take it to logical end. Be prepared for that.
In fact, it should be dismissed with costs, my lord, because there is no trialable issues.
Be prepared for that. We don't know, whatever your instructions are, you look into it, we find that this is something sought to be only for the purpose of delaying the whole thing,
No, my lord,
we will take it to logical.
my lord,
Because my
the issue is
execution
that we have
proceedings
not
are
received any
already put on
documents.
hold because of this proceeding, my lord. It is
Lord,
absolutely.
we
there's
have not
no
received
merits.
any documents with, along with the plaint. And they say that they have produced, it is not marked. I am not, I have not seen even a single document, my lord.
My lord, since
which is there.
evidence is not, like documents won't be marked.
Where are the documents?
My lord, in the lower court with the trial court, my lord.
Sure.
Because in the commercial court, the time of filing, we can give original documents. So all the original documents are there at the commercial court. Since evidence was not laid, the documents are not marked. But the detail of document clearly says original invoice,
Just
original
let
ledger.
them be
account.
directed to furnish.
What is the reason for your non-appearance?
My lord, it was received by a clerk. My lord, on that day, he did not inform us regarding this, what is there. My lord, that also I have taken one of the contention, my lord, order 29 rule 2. At least principal officer of any of the company, this was not served. Even the bailiff, they say that bailiff had served and he had served on the clerk is what the shara which is there. My lord,
You have a better reason.
My lord,
my lord,
there
that
is
is.
there is absolutely not a single merit point on merit, my lord. in the appeal.
My lord, let them give the document to me, my lord, I will make submission.
What are you saying that this decree must go?
My lord, I must be given an opportunity to defend.
There is a money decree, you deposit the amount, complete amount with the trial court. We will allow this appeal subject to cost to him. And you will work it out. You may have a good case. He is not entitled to a single penny. Well, you will work it out. Deposit the complete decree to him.
Exactly,
will
because,
seek instruction,
because
my
that's
lord.
what summary suit is, my lord. When a summons goes in a summary suit matter, the summons form itself says you have to appear before the court and pay the 100% of the amount to seeking leave to defend.
Be heard.
Yeah.
The court will hear it,
Yes.
but there is a money decree against you.
Please,
Deposit the complete amount with the trial court. Pay cost, whatever we will impose. Surely there has to be some deterrent.
please, my lord.
Yes.
Pay cost, we will restore the suit, work it out. Get your instructions.
Please, my lord.
Okay.
Yes.
Very good. Just say the request of counsel for the appellant re-notify. When do you want?
2 days, my lord.
Monday?
Monday.
7-1. Seal number 30.
To appeal for the response, please.
My lords, may grant us a short accommodation to file our rejoinder to their objections. Which objections to what, ma'am?
Notes on 21.
20.
I have filed an objections to their IA.
For
Was-
donation? For which application?
For their IA number 2, which is for the stay and operation of the impugned order. This is a
What is the issue?
Lords, this is an appeal against granting injunction in my favor. I am the plaintiff before the commercial court. The suit is one of a suit for specific performance. There's a agreement of sale titled as term sheet. And this was an ex parte order granted on 15/5/2024, which is now been confirmed by the impugned order. It's dated 25/9/2024, please. Entire dispute runs around the agreement, which is at Annexure D, running page number 138.
What is the stage of the suit now?
Please note, it is now set down for framing of issues, and there was a memo filed by me that I am ready and willing to deposit the balance sale consideration before the trial court. So it is for that.
My lords, seeking a short accommodation to file our rejoinder. Is there any stay of this order?
No, lords, no interim order,
no.
because the
Why don't you work it out before the trial court? My lords, I'll have to seek. This specific performance, there is a stay for that. Yes. Who is the counsel? My lords, Holla and Holla, Vivek Holla. What is the difficulty for the counsel? My lords, he's just running on his legs, my lords. There When do you want? my lords, 10 days. 10 days. The request for adjournment is made on behalf of the counsel for the appellant. Grateful, my. There is no stay now.
no, lords.
That stay in your favor is operating.
Lords, it's an
Yes.
injunction for non-alienation. Please. It's in my favor.
25-2.
Grateful.
Grateful.
31. Shri Naveen Kumar.
Mr. Naveen Kumar pays time, your kindly call on Friday.
Why?
He is not, is out of station, your. Kindly call on Friday, your.
Let's say that issue notice. Return of the loan. Serve the other side.
23-4. 32. Serial number 32.
Name this the file, man. This is password.
Password. 33.
The issue notice.
23-4, 34, serial number 34.
Yes.
Suit for partition, my lord, partly allowed by the trial court, my lord. On that basis, we have filed the appeal before this court, my lord. Last occasion, my lord, on 18/12/2004, issued notice to the other side, my lord, and also granted not to alienate the property.
Now, what is the position? Stay has been given, the proceedings are going on.
Ah, yes,
The final
No, my lord, sir, not.
not to alienate the property.
is there. But very well. But is there any, these are all family members?
Yes, yes,
Do you want to look into it and?
joint family property.
sit
ancestral.
across? Do you want to sit across and decide? No.
My lord, respond number
They are
5.
the
is
purchasers, my lord. He is
The purchaser.
purchaser.
He is
He
the purchaser.
prop-
Who is appearing for the other family members?
Notice has still not gone. Served.
Everyone is served.
Served. Sorry. Even before the trial court, they remained absent. Even before the trial court, they remained absent. Respondents 1 to 4 hearing, his
Why are
own
they
family
not
members.
Well, they appointed the advocate, my represented on behalf of them, my lord. I do not know why they are unrepresented and all those things. my lord.
You have purchased the property.
Please note.
Who is in possession?
I am in possession.
How many properties are there?
My lords, there are totally 19 properties, my lords.
All 19 partition.
No, my lords. Items 1 to 8 I have purchased. And suit schedule properties 9 to 19, it is still in their possession, my lords. It is still a joint family property. They admit,
That you have not purchased.
no, my lord, that I have not purchased.
Is their outlook.
Please note.
So what is your challenge?
Well, we are not, these petitioners, my lord, they are not concerned, executed any sale deed in favor of these persons, my lord, and also we have entitled share, my lord. He himself was admitted in the cross-examination, other things, my lord. These properties are belonging to joint family. We are also entitled for share in this property. This was admitted by them. In spite of
To you, all these 8 properties,
My lord,
Eight
respondent 1 to 4, my lords.
the
the ground that they have the title.
Please, my lords.
On what basis?
My lords, it is their ancestral property, my lords,
Ancestral.
and for discharge of loan, what the family had obtained, they had sold this property, items 1 to 8 to me, my lords.
Okay. But why they have not signed it? If it was an ancestral property.
My lords, we were not told about the sisters.
All the brothers have told it.
Please.
even in the cross-examination, he himself was admitted stating that I got the opinion from the legal opinion. My advocate says that they are also entitled the share in the said properties. That was admitted by him. My relationship is admitted. Properties are belonging to joint family.
Money has gone to the brothers.
Yes, my lord.
They will be entitled to money.
No, I have not received any single.
Well, where are they? Brothers.
Brothers.
It's a collusive suit, my lords. The collusive suit between plaintiff and defendants 1 to 4.
Hello. This is not the collision suit. my
That's
lord.
why
We
they
are
remain
entitled our legal share. We demanded they are
They're in the form of money.
Difficult to say.
There are other items of the suit schedule property, my lords, which is still in their joint possession. And the plaintiff admits those items are still not partitioned and they are also ancestral joint family properties.
there is no any partition prior to this filing of the suit. my lord.
Suit is against those remaining properties also.
Oh, yes, yes.
My lords,
It's a
initially,
composite partition.
I-
my lords, initially they had filed suit
Trial-
only in
trial court was
respect of
also
properties which
determined
were
by
sold to
chair.
me. Thereafter, I filed written statement and brought to the notice of the court, there are other properties belonging to the joint family. Subsequently, they filed an amendment application. They got the plaint amended and included the other suit schedule properties, my lords.
You kindly page.
How do you know they have other properties?
My lords, the very adjoining properties belongs to them, my lords.
Oh, you are sitting.
Please,
Oh,
in the same village.
what do you say?
Kindly say, I I have got legal right over the said properties, my lord. The trial court was also allotted my share in the remaining other properties.
He's not denying that.
Therefore, my lord, I am legally entitled my share, our share, that's all. So, they are not denied regarding our relationship as well as the property right over the.
Are you in touch with your brothers?
Yes, yes, ma'am.
Why don't you ask them to appear?
Well, I do not know, my lord. We have got some strange relationship between after filing of the suit and other things, my lord. We sought for the partition and held a panchayat and other things, my lord. They did not come forward to give my share.
Still have 9 properties that need to be partitioned.
The allotted share in before the trial court, my lord, regarding the entire family property was included. You may kindly see the page number 41, my lord, trial court order, my lord.
How many brothers, sisters are there?
2
Father
sisters,
and 3 brothers.
3 brothers.
Defendants.
3 brothers
Plaintiffs,
and
2 sisters.
D1 is the
D1 is the
father.
father.
5 plus 6.
Yes,
Please,
yes,
ma'am.
6.
See, we can't, like, unless and others are there also, we can't. They say this. You appear for which respondent?
5th respondent.
So is present for R5. There is no appearance for the other respondents. List on interim order if I need to continue. Interim order there?
So,
Is interim order there?
Yes, my lords. But
interim
my
order.
lords, there was no interim order before the trial court, my lords.
And also last occasion, the Honorable Court directed to not to alienate the properties.
Interim order dated 18/12/24
Yes.
is continued till the next date of hearing.
In the meanwhile, call for the records from the trial court.
There must be some proceedings going on, no?
No,
No,
my
no.
lords. Because the plaintiff suit is dismissed, there are now other proceedings.
Trial court record the disposition.
22-4,
Much obliged.
serial number 35. 35.
Preparing for the appellant in this, very short accommodation is.
Not in this.
What is job accommodation?
We have engaged the senior counsel and some inconvenience is there to the senior counsel and some time is required. My lord.
Yes, appeal has been rendered infructuous. We have complied with the order of the Honorable Single Judge. The BBMP was directed to comply with certain directions. And BBMP has complied with the directions and has initiated the action as per law. Nothing further survives in this writ appeal because the Honorable Single Judge's direction have been acted upon with the true letter and spirit. And the compliance report is placed before and
Is the date of the
order is dated 4th January 24, my lord.
see that position has been set aside, huh?
That's what they say, my lord.
Set aside.
Set aside and then parties privately entered into certain arrangements, which was taken note of. And those parties, 10 years later, engage with another developer and transfer the properties, even though it's developed and allottees of the society have occupied it.
Can you have it on tomorrow?
And they've been found guilty of mala fides in a connected writ. I mean, the private respondent is before in appeal. Though it was a challenge against the statutory notice, the private respondent has come in appeal.
The landowners have not come.
No, the private respondent has come. Who's
These private respondents,
they acquired from the landowners subsequently,
previous, before acquisition and after?
much later,
Much later,
a decade later, close to 2 decades later.
after the acquisition.
After the acquisition was set aside 2 decades later, in the interim, there was a private arrangement between the society and the landowners because the society had already formed the layout.
And ultimately, these are the notices, my lord, which are issued under section 321, confirmatory orders.
Essentially a dispute
We
between
have-
the corporation and the society. We took a stand that the notices were issued at the behest of the private respondents, colorable exercise of power. In that context, an inquiry also was ordered by the learned single judge and a report has been filed.
And it is found that no such
Yeah, that is a different matter.
Transfer for the appellant. We wait in March 2nd.
12-3.
Let it be as a last chance, my lord, because writ has been.
Final of.
Both the matters, 35 and 36.
Both of them, 35 and 36. Both of them, 35 and 36.
36 are connected.
Correct.
Yes, see.
37 Arjun, 38 Bhushan.
I appear for the respondents.
My lords, the matter pertains to pay parity, my lords. This is the same matter pertaining to Ministry of Information and Broadcasting. The respondent counsel had to report on that.
Yes, your lordships, the reply that I got was that the benefit was given to the superintending engineers who are in the pay band 4, not pay band 3, as the.
No, he says he is entitled to grade pay of 8,700. Have you got the instructions, man? Have you got the instructions? Can you hear us?
Madam, ಕೇಳಿಸುತ್ತಾ madam?
ಮೇಡಮ್ ಕೇಳಿಸ್ತಾ ಇದೆಯಾ ಮಾತಾಡೋದು?
ಕೇಳಿಸ್ತಾ ಇದೆ. Yes.
ಹೇಳಿ.
Now, have you got the instructions?
Yes, your lordships. My instruction is that these persons are superintending engineers of CCW, the AIR, who are in the pay band of 4. And this has been done against certain persons who have gone to court and they got an order of PP4 only. Your lordships, but they are pay band 4 people. And they are the superintending engineers, not
Where is that order?
Lordships, it is here. It is
I've submitted to the honorable court, my lords, and I've shared this the same with the opposite counsel as well. If I may be permitted to read the order, my lords.
They are also superintending engineers. They are also in band 4.
Your lordships, as far as the appellant is concerned, the petitioner is concerned, he is the architect, senior architect. He retired as a senior architect.
What was his pay band?
He was in PB3 band.
What was your pay band?
Pay band 4, my lords. If I could draw.
No, but tell us, this is only for superintending engineers.
My lords, if I could draw the court's attention to page 106, my lords. This is the C&R rules, my lords, which I've presented before the honorable tribunal as well.
What is the submission?
My lords, it clearly shows in the C&R rules that senior architect and superintending engineers are in the same cadre, my lords.
Where is that? How do we get that?
My lords, at page 106, my lords.
This is the
Gazette dated 30th April 1988, my lords.
106?
106. 28 March.
This is annexure R1, my lords.
Yes.
It's an annexure to the reply statement, my lords, filed by the department.
Where are these? Where is the architect here?
Senior architect is at schedule number 1, my lord, senior architect. And 2, there's superintending surveyor of works, electrical superintending engineers.
When did you retire?
I retired in 2017, my lords.
What was your claim before tribunal?
Claim was that, my lords, the superintending engineers of CPWD and the superintending engineers of All India Radio and senior architects are in the same cadre, my lords.
Where is your prayer in the OA?
It is at page number. Page number 36, my lords. This is a prayer in the OA, my lords.
What was the scale you are seeking?
Scale I'm seeking is in pay band 4, my lords. Grade pay 8,700.
What were you drawing when on the date of retirement?
I was drawing PB 3, my lords. Pay band 3.
Pay band 3,
Pay band 3.
grade pay.
7,600.
One of the
Which is the court orders by which these people 8,700 was given?
it is at Annexure A 19, my lords. This is with respect to one Mr. Nurul Huda versus Union of India. And my immediate seniors were extended the higher pay grade, my lords.
Where?
That is presented at Annexure A 18, my lords.
Page?
Page 62. OA number 1977 of 2011.
He is also this Rajiv.
He's
Dixit.
senior architect, my lords. My immediate senior.
Oh. Where is the direction?
It is at page number. Page number 78 has the operating portion, my lords. Para 24. Para 24, 25.
How many years of service is required?
9 years is required, my lords.
Huh?
Which 9 years, my lords.
No, it says 13 years. No, 9 years.
9 years, my lords.
How do we get that? And where is your judgment before the tribunal?
Judgment before the tribunal is at Annexure D, my lords, at page 141. The operative portion being
From which date you are asking?
from the year 2007, my lords. That's the year in which I was promoted to the post of senior architect, my lords.
No. Huda, everything were given from a initial date.
It was granted to my immediate seniors from the date of their promotions itself, my lords.
Where is that show us?
That is not apparent, my lords, but the order which I've presented to the court covers these conditions, my lords.
No, what is
Where the
his
same,
senior's name? Dixit.
please, my lords, Rajiv Dixit.
No, where is that order? Where is the order of Dixit giving
Please,
him from that date?
It would be at Annexure A18, my lords. Page 62 is the is where the order starts. And
See operative portion
please, my lords.
with effect from 28/10/80 when the applicant completed 13 years of service.
Please, my lords.
So it is not from that 13 years of service. When did you complete 13 years of service?
My lords, I have not completed 13 years of service because I've reached my age of superannuation, my lords, in the year 2017.
And where is the scheme for grant of grade pay of 8,700?
Please, my lords.
Which are the conditions need to be seen?
No conditions as such, my lords, but the CPWD senior architects.
So one thing, we'll have it tomorrow or day after.
Please,
Just say notified day after. Let me just see it.
please.
24-1.
Lordships. Maybe posted day after tomorrow, your lordship.
Yes.
24-1, madam. 39-40 adjourned, 41.
Yes.
So this is an appeal arising out of final decree proceedings amongst the suit for setting aside an earlier compromise decree was filed. And my lord, it was decreed by way of a preliminary decree. It was a hybrid suit in the sense two causes of action were merged. One, to set aside an earlier compromise decree, and consequently, in view of the if the court were to set aside the compromise decree, for a share in those assets of the firm in proportion to the party's entitlement. Suit came to be decreed by way of a preliminary decree, and shares had to be worked out.
Settlement set aside.
Settlement was not set aside.
Hmm.
Strangely, settlement was not set aside, yet the court goes ahead and divides.
How would you reconcile between settlement agreement and this decree?
Absolutely. And my lord, a fresh suit itself is barred under Order 23, 3A. And therefore, the jurisdictional point was missed out, strangely.
No, but settlement can be challenged.
Can be challenged, but not in a separate suit.
No.
Can we see Order 23 rule?
No, there is an interpretation by Supreme Court on this. There are judgments which can be gone into.
We've done.
It necessarily be, the question would be before the same court or where?
For the same court, on the
When
same
to the-
proceeding.
No, these are out of court settlement
No.
before the court.
Yes.
Ah.
So
And
therefore,
what is the ground for settlement, setting aside the settlement?
he didn't set aside, the learned judge didn't set aside the settlement.
No, we are asking you, when did,
On the other side. Yeah.
where did the settlement entered?
Sorry.
Before the court or outside the court?
Inside, before the court, a compromise decree.
Oh, compromise day.
Compromise decree as far back as 84.
23 under Order 23, Rule 3.
Yes, and reopened by a fresh suit in 99. And this point of jurisdiction not urged by any counsel.
No, is it opened or reopened or was it set aside?
Lord, I'm sorry, may I make this submission? I appear for the respondents 2 to 4.
Yes.
My Lord, my father, my Lord, died in 1983 while I was minor, and my mother had filed a suit for partition, which she compromised with my uncles. When I attained majority, my Lord, I filed a suit challenging the decree, saying
So
that
you
that
are
decree
not
is not
part of the
binding on me.
settlement.
Yes, my Lord. My Lord, may I make this submission, my Lord? The decree passed in my suit has been affirmed by this court 10 years ago in 2015 in RFA.
Oh,
It's
okay,
become
the same.
final. Yes, my Lord. The decree passed in my suit has become final. In FDP proceedings, my Lord, now the appeal is filed against an order passed in the FDP proceedings, challenging the decree passed in my suit. That, my Lord, in my humble submission, is impermissible.
On the ground that the decree has already been upheld.
Yes, my Lord, decree passed in my suit has been upheld by this Honorable Court, my Lord, in 2015 in RFA 1374 of 2009. Lord, my colleague, Lord, who's before your Lordship, my Lord, has the synopsis. May I, with your Lordship's permission, my Lord, request him to hand over the synopsis.
Just give it to him.
Sir. Citation.
Having suffered a decree, my Lord, which has been affirmed by this Honorable Court in 2015, Lord, it is now too late in the day, my Lord, for my learned friend to reopen that question in a final
But
decree
in any
proceedings.
case, possibly, are you challenging that preliminary decree also?
Yes, my lord, I do understand. I'm fully conscious with due respect, my lord, that the limited grounds I am entitled to challenge it on. And I will convince the court that we stand within those grounds.
Very well, it's all right. But that's you can say that that's a caveat from his side. So
Absolutely.
to possibly.
Quite right. My friend has raised the right point, which I have to meet with. I would like to refer to some, the LCRs have come, I think.
Just give it to him, but you file it e-filing. Give it back, ma'am. We want e-filing. Okay? But you want to file anything?
Yes, we'll file our synopsis as well.
You will file it?
Yes, we'll also file it.
That Leonard, senior counsel appearing for the respondents 2 to 4 has filed written submissions, citations, and only 2. That's all. Copy thereof has been given to the counsel appearing for the appellant, who shall also file the submissions along with the citations, if any, through e-filing.
Please,
Okay. When will you file?
week's time.
Weeks, 2 weeks. Just have it in February, second or last week, second week.
20th February,
Great.
Next.
serial
Right.
number 42. So 20th February, February 20th.
Serial number 42, Mr. S.G. Bhagwan made a mention at 10:30, and my lord asked him to inform the other side, and also if the other side has no objection to take the time, and S.G. Bhagwan has undertaken to inform the other side when the date is given. He is filing a memo to that effect.
Seeking what? Memo is for what?
Memo seeking time and requesting this honorable court to extend the interim order.
Just say that Mr. S.C. Bhagwan has sought adjournment
Yes.
in the appeal, full stop. Re-notify on interim order, if any, just check up to continue. Mr. Ariga, you are appearing for him?
No, my lord. No, he requested me, my lord, that
Just say that Mr. Ariga appears for Mr. S.C. Bhagwan.
Yes.
S.C. Bhagwan seeks an adjournment. You have informed Mr. Gautam Chand. The other side.
He has undertaken to inform Mr. Gautam Chand when the date is given.
Re-notify interim order, if any, to continue.
26/3,
Please, my lord, I shall.
past door matters. 14,
Come.
Earlier, immediately there is no question of anonymity, subsequently sitting in a three-judge bench, they said, but here also the opposition, what they say, that it is like, a long delay of 70 days, long delay of 80 days, unlike, you're also aware, in the normal civil matters.
Section 5.
Yes, but section 5, 70 days, 100 days, we associate, we have no objection and but here, because of that, so here, there's a delay of more than 90 days.
Over and above 60.
Yes. Over and above that, it's a delay of, and the reasons for what, even as your lordships have said, that it's just administrative, he retired, they retired, and they also got the three judges bench, they have said, and in fact, they rejected it on the ground that no proper reasons have been assigned. Obviously, your lordship discretion, too, and.
But here, now the Supreme Court has said, so malafide, long delay, short, small delay, no malafide, no negligence. No negligence. Small delay, no negligence.
And here, what is this long delay of 75 days, they say. Only a short delay can be condoned, and that also is an exception.
No, but you will take benefit of that long delay, what we are saying. If there is a long delay, the Supreme Court say long delay is not impermissible.
Yes, that's why, because it's not permissible, because there is more than 75, there is 94 days delay that is.
See, we have given one recently judgment.
He said that your lordships have already taken a view, my lord, so I'm not aware of.
That also we have followed that only, but on facts, we have translated the judgments in the facts.
Yes.
Applicability.
And if I'm not mistaken, subject to correction, your lordships have condoned the delay.
No, not in all 3. There were 3 appeals. One, we rejected it. In other 2, we have, being a small delay, we have allowed it. We have gone in facts, on facts.
Here also, they delayed the application, the lordship sees, not given, simply they say he, that person retired, this person retired, not so, whether these are the reasons that could convince your lordships with regard to whether they are.
Yes, what do you say?
My signer is coming, my lord, 2 minutes.
Who is the counsel?
Sriranga is.
Just pass over, let's
Yes,
have
madam.
next matter.
16, serial number 16.
Yes, ma'am.
So we spoke to the party, my lords. He is again seeking some time, my lords. He is making
what?
a request for some time to.
For what? For
for
payment?
Payment, my
Don't,
lords.
don't invite an order from us for this thing, period. You will base your submission only on the writ court order and then proceed to pay him. Whenever you want, you pay him. Does the writ court says any time period?
No, lords.
Why? Then take it. We say don't. Otherwise, we'll bind you for how much time? 2 weeks, 3 weeks. We'll bind you and you will be bound by that. We don't mind. What do you say, Mr. Ariga? How much time, ma'am?
My lords.
We can do one thing. If she asking for time, we will ask him to file an undertaking. You'll do that?
Please.
We'll do that, file it. See, there has to be sanctity.
Please, I understand.
When was that statement made?
It was in the month of November 2023, my lords.
23?
3.
Where are we today?
I
So
understand.
this is nothing, but don't mind us using this word, a ploy to come out. Just a ploy to come out. So reason we are saying, we say no, if you simpliciter withdraw it, you will work it out. Mr. Ariga will work it out, the worth of that statement made in the writ court. Take a call. This is not the way. Once you have given it, very well, we'll look into it, we will say so. Where is that order, Mr. Ariga? Where is that order?
Files.
Additional objection, because filed on 16/1/2000, dated 16/1/2000.
Just show us, ma'am. Which page is that, Mr.? Do we have them? Where have you filed? Have you filed it with memo? Otherwise, what are your instructions? How much time?
Lords, he seeks 6 months' time, my lords. Or may I request for a judicial order, my lords?
Every order of ours is a judicial order. Even this also, just say. Just show us that. What happened to this petition?
It was
Stating?
Auction sale should be conducted in, auction sale was conducted, spot sale was conducted, and court sale, day after tomorrow.
For,
Court sale,
court sale is for tomorrow.
please.
Property is also not worth the amount to which is
Now, let's see what is your claim here. What is your challenge?
That's it. It's a suit for specific performance, my lords. The respondent states that the sale consideration was fixed at 19 lakhs, my lords. And this agreement, my lords, was entered in the month of September 2013, my lords.
No, but tell us one thing. What was the proceedings before the writ court?
My lords, the auction was challenged, my lords. The date was fixed for auction in the execution, my lords. And the same was challenged before the writ court, my lords, on the ground that the valuation is not proper. The property has not been valued properly. And there was a stay order, and subsequently, my lords, recently the writ petition has been disposed of, my lords, and the court has directed the executing court to conduct auction.
In the execution?
Please, my lords. That is how the auction has taken place. Court sale is fixed day after tomorrow.
And that execution is pursuant to this award.
Yes, my lords.
What remains, ma'am?
That's
Actually, what remains? Tell us. When we have crossed and there were no stay proceedings of the contempt of the execution. Execution went ahead and has put the property on sale to recover the decretal amount.
execution was stayed for some time, my lords.
Yes, but today
Yes,
it was
Now-
vacated,
yes,
executing court went ahead.
please, please.
This appeal remained here only. It did not move forward.
Because there was delay, my lords.
Pardon?
There was a delay. The appeal was filed belatedly.
How much is the delay?
That's 150 days.
150 days. And this is a memorandum under 37 and 31A. Just show the file, ma'am. The delay has not been condoned.
A delay has been, no, my lords. Delay has not been condoned. He has filed objections, my lords.
$150 days.
Please.
Let's see. Oh, this is a suit. And this is a commercial suit. Or this is a normal suit? OS. RFP. So you got your money back, 19 lakhs.
No, my lords. So this suit,
That's right.
it, the,
That is the consideration for the land, which was agreed to be sold in my.
No, instead of specific performance,
yes.
what you have got is the 19 lakhs must be returned, refunded to you.
Yes.
That's all, along with interest. So you have not challenged for specific performance. They have come in. What is your defense?
Lords, there was a GPA, my lords, executed, my lords, in the month of January 2014, my lords. However, we say, my lords, that was the money that was advanced to, my lords, to the defendant. However, he has And the defense was that the sale agreement is denied, my lords. However, in the cross-examination, he has admitted the sale agreement, my lords. and
Admitted the,
Sale agreement.
then,
So on that count, my lords, the court has, but also the court has held that he is not eligible for specific performance if
Right,
you are
he
the
has not
fact that
come.
he is a money lender.
so what else? Where is the finding, Mr. Ariga?
The legally one in this cross-examination has indicated that he had borrowed for the purpose of business and he has utilized the loan amount for the said purpose. Technically, the rate of interest is not mentioned, but in actually T1, the recruitment hearing has mentioned that he has availed the loan of rupees 6,43,000 and promised to pay the same with the interest at the rate of 2% per annum. In the actually the basic hearing in its legal statement has specifically mentioned that the government has borrowed the loan of rupees 19 lakhs and agreed to repay the same with interest at the rate of 12%. He explains about the agreement of sale. He explains about the rate of interest.
Internal page 51, my lords.
Yes, ma'am.
The page number 51, my lords, is the portion where the trial court specifically observes that the DW1 has admitted the sale agreement. Lords, however, my lords, the sale agreement, the only ground available to me is, my lords, the sale agreement was entered into on 29/9/2013. And all the witnesses, my lords, to the sale agreement say that on that day, money was, sale consideration was given to the defendant. However, my lords, the bank statement of account, my lords, which was produced by him at exhibit P6, my lords, show that the sale consideration was given on 28/9/2013 itself. That
So
is amount.
But what difference it would make? Still the money has come to you?
Money has come to me, my lords, but the money is totally amounting to 9,90,000. Whereas they say the sale consideration in the agreement is fixed at 19 lakhs.
Where do you set up that case? Where have you set up that case?
Page number 49, my lords. Page number 48 and 49, my lords. Paragraph number 65, my lords. The trial court discusses that part, my lords.
No, that is internal page, no?
Paragraph number 65, I'm sorry. Paragraph-
9,900 said checks were encashed on this, therefore it appears in his first date of correspondence might have deposed without verifying the necessary. However, the said evidence is not contrary to the content. In the play, the plaintiff has mentioned in advance rule and answer. Therefore, the said minor contradiction of item cost cannot be done. On the other hand, defendant has taken a borrowing. The determining cause of the depose that the signature.
Specific contention of the plaintiff is that, my lords, 10 lakhs was given through check and 9 lakhs was given in cash, my lords. With respect to, my lords, the amount given through the check, my lords, 9,90,000, my lords, there is a entry in the bank account statements. Whereas, my lords, with respect to the remaining 9 lakhs, my lords, there is no document, my lords.
What do you say, Mr. Ariga? What is the basis for 19 lakhs?
And later the remaining amount is paid by cash. For the first amount, there is it is a check transaction and remaining amount was paid in cash.
Who
And
dep-
there is coming, pleading is also there. In the plaintiff there is a pleading and in the evidence of PW1 has also stated this is the amount to be yes, borrowed.
Where is the deposition? Is the file here?
ಇಪ್ಪತ್ತೊಂಬತ್ತು ಒಂಬತ್ತು 2013 19 ಲಕ್ಷ ಹಣವನ್ನು ಕೊಟ್ಟು ಕರಾರು ಮಾಡಿರುತ್ತೇನೆ. ಅದು 19 ಲಕ್ಷವನ್ನು ಕರಾರು ದಿನವೊಂದಕ್ಕೆ ಕೊಟ್ಟಿದ್ದೇನೆ. 10 ಲಕ್ಷ ಹಣವನ್ನು ಚೆಕ್ ರೂಪದಲ್ಲಿ ಹಾಗೂ 9 ಲಕ್ಷ ಹಣವನ್ನು ನಗದಾಗಿ ಕೊಟ್ಟಿದ್ದೇನೆ. That 10 lakhs in by check and 9 lakhs in cash. ನಾನು ತಿರುಮಂಜೇಶ್ವರ ಶಾಖೆ ಕರ್ನಾಟಕ ಬ್ಯಾಂಕ್ನಲ್ಲಿ ಚೆಕ್ ಕೊಟ್ಟಿದ್ದೇನೆ. And in the cross-examination, this has the cross-examination on this, they just this what from where did you get this money? He says, I am running a Kalyana Mandal and for the past 5 to 6 years, I get 7 to 8 lakhs income. And from the ಕೃಷಿಯಿಂದ ವರ್ಷಕ್ಕೆ 2 ಲಕ್ಷ ರೂಪಾಯಿ ವರಮಾನ ಇದೆ. ಕಳೆದ 5-6 ವರ್ಷಗಳಿಂದ ನನಗೆ ಪ್ರತಿವಾದಿ ಎಚ್ ನರಸಿಂಹನಾಯಕ್ ಗೊತ್ತು. That I know the defendant and there is no cross-examination on the part that the check, the cash is not paid.
Where does the learned judge deals with this? Hmm?
Then exhibit is an independent date 29/9/2013 and initially really mentioned that the defendant has sought a financial assistance of rupees 19 from the plaintiff for a period of 3 months. Then this particular payment of the page 64. Page 64. So, last part of 1:10.
Hmm.
The further cross-examination by the is that as per exhibit P6, the total amount of debt is 9,90,000. PWM reports that he has paid 9,10,000 in cash and rupees 9,90,000 through checks on the date of exhibit P2 agreement.
Where are you reading?
Internal pages 48 and 164.
On perusal of the materials, it could be noted plaintiff has not paid it in the plaintiff as to how much loan amount he has paid in cash. It only in the cross-examination when the counsel for the defendant is asked, he reports that on the date of the agreement, 10 lakhs was paid through checks and remaining amount. Subsequently, when the plaintiff has produced exhibit P6, it revealed that the said checks totally amounts to the structure and cash. Therefore, it appears that PWM.
On that is page 56, paragraph 76. 76. On appreciation of entire evidence of control, reduced by both the parties. This court has come to the conclusion that the defendant has found loan of rupees 19 lakhs on the paper and exhibit agreement is exhibit P2. The plaintiff has also proved that the defendant has executed GP of 6,014. PW1 and PW1 have clearly admitted in their cross-examination that no consideration is paid on the date of execution of GPA, that is GPA. GPA, under GPA, no payment, but under the agreement of sale, the payment was made. That is the conclusion of the trial. And the court orders only for refund of that 19 lakhs, which was borrowed on 29/9/2013 with the payment.
But no, where is the a concrete finding?
The paying, 36.
Does the GPA says 19 lakhs?
No, GPA does not say GPA.
Document, there is no reference to exhibit P2 of the agreement payment for consideration and therefore P3 document is registered without supported by the any. However, DW1 has admitted signature and execution of GPA in his hence issue number 1 is partially affirmative and answer in affirmative. Since the defendant has deposed that he has not received any amount on this, the GPA executed by under pressure, hence the issue is answered.
It is under the agreement and by cash of 9 lakhs and witnesses have deposed.
Was the agreement before or after?
Was before 29/9/2013 is the agreement of sale.
Okay.
GPA was on 6/1/2024 because.
24?
2014.
14.
2014.
That's right.
Because the GPA, since he did not repay the amount, the defendant, the appellant executes the GPA.
How do we get that? Where is the reference to the agreement?
There's no reference in the, there is no reference about the agreement in the GPA.
There is no reference.
There is
Agreement of sale is spoken to by the PW1, PW.
We are only asking where is the reference in the agreement, wherever document of 19 lakhs odd, which he has signed. Which he has signed. We want to see the date. Where is it? Which page?
P2. P2.
Exhibit B2 is the agreement of sale.
Yes.
In that, there is reference.
Does it so?
It says in Kannada, Kaya Karalike Karanavaka, Sthirasthya Ottu Stharake. That means Rupai 19 lakhs. Ite Dara ನಿರ್ಣಯಿಸಿದ್ದು ಕಾಲ್ ಮಾಡುವ ಈ ದಿನದಂದು ಎರಡನೇ ಪಾರ್ಟಿಯವರು, that is second party, has paid the amount that is by tax application, tax number. So how the ಪಾವತಿ ಮಾಡಿದ್ದು remaining amount is paid in cash. ಉಳಿದ ಹಣವನ್ನು ನಗದು ರೂಪದಲ್ಲಿ ಪಾವತಿ ಮಾಡಿರುತ್ತಾರೆ.
Where is this?
There are two witnesses.
Where is this document? This,
Exhibit P2.
is it on record of the appeal?
They have not placed the.
No,
This exhibit P2, they have not.
we have only placed the judgment and decree, my lords.
Hmm?
We placed only the judgment and decree.
That's all.
Please. Procedure is records to be called for, my lords.
But how would you accept this, ma'am? The agreement to sale executed in 2014 records part in check and part in cash.
Please, my lords.
And he has put his signature, there are witnesses. It appears even the trial court has gone on this basis.
Please, solely on the basis of the
Deposition.
deposition, my lords, the trial court has held that 10 lakhs has been paid as cash. 9 lakhs has been paid as cash.
Agreement of sale. That is
9,90,000.
What do you say, ma'am?
That's why, my lords, the
No further time, ma'am. We have spent a lot of time on this.
his
See, we
specific,
meet, huh?
lords, he says, my lords, that he has only taken 10 lakhs, my lords,
You're
which
right.
is,
How would you answer his signatures being put on the agreement to sale? Which says also cash.
he has admitted the sale agreement also, my lords.
Huh?
He has admitted the sale agreement.
So, but how would you come out of that stipulation of cash also?
Please,
Where is that document, Mr. Ariga, just show us? But that's in Kannada.
that's in Kannada.
But the translation is, it's executed in 2014,
13, my lords.
agreement to sell. When was the cash given?
same thing.
As the same day.
But in the statement of accounts, my lords, it was on 28th, my lords,
At the
28,
form of
9,
checks.
2013.
In the form of checks.
Please, my lords.
We don't know. That orders, that agreement to sell says cash also.
Cash also.
It says cash also.
And one of the witnesses to this is the PW5. He says that it was cited in his presence and now it has taken. And my lord may kindly see this property when it was brought for sale, the first option, the first bid was 44 lakhs. Then they take up a contention, the property value is much more than 44 lakhs, therefore the auction proceeding should be.
But how are we concerned with that?
That is now, the technical amount itself is about 47.5 lakhs. And from 2013, he has enjoyed that money.
We've asked for the trial court. I know, but we have to get it now. We can't rely on. Can't rely on. And we trial it down to the, even the trial court record will not. Just say that trial court record be requisitioned. We should have something to see before the next date of hearing, re-notify. Just give it in February, man.
19 to
It's, may I seek for an order of stay, my lords?
No chance. I have a clear decree against you. And I must say that you have, this matter has traveled this stage or this far.
Nothing survives, my lords, if the sale gets done.
And mind it, when these execution proceedings were pending, you did not make any attempt to even seek the stay of the proceedings. And this has reached the stage of sale.
That's precisely because he couldn't arrange the court fee, my lords. We have stated the same.
Then what is the way out to satisfy the decree? This is the way out. Next. Come, Mr. Sriranga, come.
Right.
How would you explain that delay, Mr. Ranga?
Not, this was something which happened during COVID period, my lord. I have explained in the affidavit.
All
Plus-
COVID?
No,
All period.
not all that, my lord. Apart from that, my lord, I have mentioned, my lord, that two of the directors, my lord, who were directly handling this, they not superannuated. And my lord, there was some delay that I have explained, my lord, in the
But you know
application,
now what
page
is the
240.
position? What is the position? What is the liability?
Lord, this is, there were two claims which have been, Lord, disposed of by the same award. There are two projects. Common arbitration is held, my lord, claim number 1 and claim number 2. That's how it has been considered. And my lord, the tribunal has awarded a substantial amount in favor of the project, my lord, which was ultimately not undertaken and completed because of various reasons, my lord, which there is also the issue of force majeure. With governmental action, whether that would amount as force majeure and was there any kind of a liability? Is prolongation cost, my lord, is the main cost that has been awarded. There are two
Then that
tables.
can't be force measure.
No. The contention that was raised was, my lord, that governmental action would amount to force majeure. This project, my lord, was stalled because of the governmental action. On that
Governmental
there is-
action is not you, but third entity.
Yes. State government. That is one of the contentions, my lord, which according to us did not, if that is something which I'm able to press, then there should be no liability on my side or his side. Because the clause force majeure specifically refers to any action by governmental agents. But I was prevented from.
It says so.
It says so. And I have raised a specific ground, my lord, that's one of the contention. Of course, my lord, there are two other contentions specifically raised. One is there is a bar on granting of interest. Tribunal, my lord, holds that there is such a clause and refers to, my lord, all the judgments and says that yes, if there is bar, I'm not supposed to grant an interest. With regard to measurement, there is a clause which says that if there is engineer causes delay in measuring and entering it in the measurement book, then that may be a situation where they may be entitled to interest. So based on that, tribunal says that because of that specific clause which is carved out as an exception, you can't say that it is a complete bar and therefore we will grant interest. That whether that would be
Discretion, huh?
But 37, my lord, discretion, future interest they have granted at 15%. I have no, my lord, say with regard to that.
From the
With regard
date
to
of,
the pendente light, my lord, there is a bar that is noticed by the tribunal also, and there is a finding.
what is the liability?
Lord, it will be around 1 crore and odd, Lord. Sorry, 49 crores with interest in one
Is it
claim.
1 or 49? There is a huge
49.
difference.
49 crores
Then we will look into it, Mr. Kannur.
and 46 crores in the second claim.
but it was on the thing of limitation. So we were on the limitation aspect of the matter. I only request is not because in these matters, I do understand in the civil matters, when there is a delay, the courts generally hear on the merits and if they find that there is.
We will do one thing, we will still hear you on delay. We are not then saying anything on them.
Because here, what my learned friend is saying is COVID, it is not that the days after the COVID, there is still a delay. Not excluding everything, the statutory period, the COVID, the Supreme Court giving all that. In spite of that, there is a delay of about 94 days. There is still a delay. So that they have to overcome that hurdle.
See, administrative reasons are no reasons.
Para 4 of my application.
And on the last occasion,
Not the only.
Advocate informed that your lordship was saying that administrative reasons cannot be a ground to condone the delay.
That's true.
They are now giving a consistent view on that.
Not
There was 75 days delay, not the three judges bench, they did not condone the delay.
It's a small delay, there is no negligence.
Yes.
That's all the parameters the Supreme Court has laid down.
Yes.
Lord, I have tried to explain, Lord, in my affidavit. I've only para 4, my Lord, apart from the COVID related issue, my Lord, I have only pointed out, my Lord, specific dates. On
See,
which
there is a huge liability, that's also we need.
huge liability.
Completely exchequer. Just imagine. Or when he said 1 crore, you may not, but see the difference, 49 crores, is it? How much is the liability?
No, Lord, there were two.
15 or 50? We will hear you on condonation, then we will have it.
On condonation of delay,
Whatever you want to show, possibly Mr. Ranga would also show, let's see that. But prima facie, administrative reasons spelled out cannot be a reason to condone. That's the.
only thing is not in these kind of cases, I can not ultimately we can only pursue your lordships and we are your lordships and but
See,
your lordship may consider whether this is a case whether delay should be condoned.
we will see it.
Yes.
Just have it. We'll have it in second week of February.
I have to file two.
Where is it? When is it?
355 of 2022, my Lord, is the other appeal. It's not listed, my Lord, but it's also
To
filed.
file a memo.
along
We
with
have to
this.
see now whether it's part of this roster or not.
It is.
It is.
It
no?
is.
Commercial appeals are here only.
Yes, yes.
Before you are.
File a memo. Is there any date in that?
No, my Lord.
But you are the, and they have filed the appeal. Same.
Same. There were two claims. And
File a memo.
they merged and passed a common award.
Mention a memo, then we will list it.
Yes,
A memo, there should be some basis.
we'll file a memo.
Thank you.
13.
I'm sorry, my Lord,
I was telling my friend that he has made me appear 3 times, but I'll get only 1 appearance.
No,
I
we
somehow
thought
missed it by a few seconds. Both times, my Lord, my calculation today went wrong somehow.
I am now thinking, there is a request made in the morning. We should adjourn it, otherwise, end up, they end up, sitting till 4:30. That we'll see tomorrow. Thank you.
Correct.